Good morning, everybody. It is 9:30. Um, so I am going to open the public hearing, but we're going to have to go into recess because nobody is here. So before we begin, if you would just all please join us in rising for the Pledge of Allegiance. Okay, so I am opening the public hearing for House Bill 1038, and we will be in just a short recess so I can try to assess our situation.
Okay, I'm reopening the public hearing on HB 1038 and invite the prime sponsor to introduce the bill.
Thank you, Mr. Chairman, honorable colleagues. It's like deja vu all over again. Some of you are probably looking at this going, geez, I thought we disposed of this just last year. And you would be right. This is the bill that this committee recommended ought to pass as amended. And the House, in all its wisdom, passed it on to the Senate. The Senate took it up. And they decided that they wanted to do a national legislative search just to make sure there was nothing hiding under any stone that may have been left unturned. This is the packet. It looks thick and daunting. Most of the pages are like the first pages. There's nothing there. This is in your email as of this morning, so you can review it at your leisure between now and your exec session that's coming up. I've reviewed the information that the Senate. So the Senate passed the bill interim study, and I was encouraged by the chair of their committee to refile the bill, to look through this and then make any changes as one may see fit. I have gone through all of this material to the best of my analysis. There's nothing in this packet that says that this bill is not a good idea. There's nothing in this packet that says that this would open up the state of New Hampshire to a legal threat if we pass this bill. This is basically a survey of state statutes across the country. Most states are like New Hampshire. So we've got restrictions on employment opportunities for registered sex offenders, and they basically all are like New Hampshire's, right? So it's for school employees, it's for people volunteering at organizations that provide direct services to minors. And we already have that on the books. That's well established. The loophole that we are trying to close in New Hampshire law is the loophole that allows a convicted sex offender to be the direct supervisor, the direct management over a minor child, or to directly employ minor children. It puts the kids at risk. It puts the registered sex offender at risk. And so this closes that loophole. I think we did the right thing last year, and I would encourage the committee to do the right thing again this year. And I will go to the Senate and review this packet with them and say there's nothing here that causes us issues. So from my point of view, nothing has changed. I would ask the committee to again recommend this ought to pass, and we pass it through the House and take it up with the Senate.
Thank you, Representative. The bill that passed the House last year was amended. Is this the amended version, or is this the original bill you filed last year?
That should be the amended version. I requested through OLS that they pass they reissue the amended version that we passed through the House.
Okay, because several people have pointed to me that this is the original, not the amended. So I want to make sure.
If that is the case, that is an error. And so I can certainly double check that. What I am requesting is that we pass the bill that the House passed. So if OLS gave me the original language, I apologize. It would have been a miscommunication between them and I. And so if somebody would file an amendment to make it the amended version, I would be obliged.
Thank you.
Mr. Chairman, if I could just say one other thing. You know, one of the big issues with this bill is the potential that, we're not going to make any employment opportunities available to registered sex offenders. And I would contend that this bill does not do that. And I would remind the committee that New Hampshire it continues with the lowest unemployment rate in the nation, if not one of the lowest. So if we're not the lowest, we're very, very close. So there is a plethora of job opportunities out there for everybody.
Thank you. Representative Manning, did you want to add some clarity to that question I had?
Yes, thank you, Mr. Chair. So I'm holding the bill that you filed, which I looked up, it appears to be the original bill you filed last year. I also have a copy of amendment number 2023-0586 that I believe is the amendment that we worked on in subcommittee. That's different than what you are proposing here.
Then I apologize. That was an oversight on my part and probably a miscommunication from OLS. What I want is what we passed last year. So if that's not that, I apologize. I'll take ownership for that oversight. I want to pass what we amended and passed last year. That's what I'm asking.
And that's what I'm asking you. That's the one you.
That is what because that's what we all agreed on.
Correct.
And so if that's not what you have, then I apologize. That I want to pass what we passed before.
Can you tell us if you recall what the change was, the amendment did to the bill? If you don't recall, that's okay. We can work it out.
So I don't recall the particular details. There was just some language reworking, and it basically brought the opposition and the proponents of the original bill together with language that we could all support. There was nothing controversial in the amendment that we passed last year, and I think that it fully accomplishes what we're trying to accomplish.
Thank you. I'll see that the entire committee gets the amended version. And
Yeah, my
then
apologies
One of us
for that.
will work with OLS. Actually, if you could call OLS and ask them to draft, you can put in my name.
I will do that as soon as I leave.
Thank you. Questions? Representative Murray.
Thank you, Mr. Chair, and thank you for taking my question. You just kind of referred a couple times to potential issues the Senate saw in their research. I'm just curious if you've heard like concerns from them that we should be aware of in moving the bill forward.
Thank you for the question. So if that was your takeaway, then I apologize because I didn't communicate clearly. So my understanding in talking with the chairwoman from the Committee on the Senate was that their committee wanted to get more information on a national scale relative to these types of laws to compare it to what we're proposing to make sure some other state hadn't tried the same thing and found themselves in trouble with the judiciary branch because of it. So and the chairman's already sent it out this morning, so you'll receive the packet. It's not that daunting. Most of these pages have no words on them. I've reviewed this. No, it's fine. The other states, the other states have never. Our law with this law, when we pass it, will make New Hampshire uniquely restrictive in that we will have it codified in law that you cannot be the direct manager, the direct supervisor of a minor child if you are a registered sex offender. That's the loophole that we're trying to close. We all agreed on. And so they didn't have this in a timely fashion to be able to work it through their system. So that's why they voted for interim study so that I could refile, look through the packet, make sure there's nothing wrong. So to the best of my knowledge, this should go through this time. Thank you for the question.
Representative Newman.
I make a question to Representative Mannion about the amendment that he has, whether it was a 2024 amendment or a 2023 amendment.
2023. This is the amendment we got out of subcommittee last year.
And a question to the chair, maybe if we could just make a copy of that for some sort of reference, we could get to comparing the two things earlier, make it easier.
Yeah, that's. I'm gonna have that version sent to everybody. I don't think that we need it for questions at this point because the changes. And Representative Mannion, perhaps you can speak to the changes. You were on the subcommittee.
Yeah, so if I remember correctly, there was some issues that Representative Lynn had with, I believe, the onus being on the employer, not the employee. There is a long list of jobs, if you will, or employer types. And if you remember last year when Representative Muse mentioned the longest sentence in a bill, that's what this was. There's a list of, so it kind of narrows it down to just these items. It was so, if I remember, all of the questions or concerns that Representative Lynn had were met. They worked on this together in this amended version, and that's the one we passed through the House. So,
Thank you. For the sake of brevity, like I said, I'll make sure everybody gets it. I'll ask if Representative Vanderbilt could be here for the executive session in case anyone has any last minute questions or no.
Is your executive session next week?
It's this Friday, next
Good.
week's holiday.
This Friday. I will try my best. I am in state, so I will absolutely try my best.
Okay, if you have questions, email them to me and I'll send them to the representative and we'll see if we can't get an answer for everybody. That can't be answered today. Further questions?
If I could just ask,
Yes.
can you give me that amendment number so I can go get that as soon as we're done? 0586H. Thank you.
Okay, see no further questions. Thank you, Representative.
Thank you.
And the chair calls Jane Graham.
Good morning, Mr. Chair, members of the committee. My name is Jane Graham. I am the Strategic Communications Administrator for the New Hampshire Department of Corrections. I think what we originally came to testify on, we believed was the unamended version. So the amended version that went through the subcommittee process, we're all right with that. So,
That's what we'll be voting on. So
okay, great.
do you have anything you want to add while you're here?
No, it was just clearing up. Our primary concern was clearing up direct service to minors that was in the original, but the amended version does provide clarification. So that's
Right.
fine for us.
Okay, thank you.
Okay, great. Thank you.
The chair calls Sergeant Richard Perot.
Like the ladies that were before me said, we were prepared to come today and testify to the unamended version, but the amended version, we're going to remain neutral on that. So, okay. Questions?
He's working on it right now. Anyone else wishing to testify on this bill who has not? Seeing none, I hereby close the public hearing on House Bill 1038. And I open a public hearing. Nope, we still got 10 minutes. 10 minutes. Hereby open a public hearing on House Bill 1204 and invite the sponsor to introduce the bill.
Thank you, Mr. Chairman, esteemed members of the Criminal Justice Committee. I am proud to sponsor HB 1204. This bill concerns the so-called open fields doctrine, which allows officials, in our case it's New Hampshire officials, to enter and conduct warrantless searches of private land beyond what's known as the curtilage immediately surrounding the home. The vast majority of private land in New Hampshire is subject to the open fields doctrine. That means that government officials currently can decide to enter someone's private land whenever they want, for whatever reason they want, even when the property owners who desire security and privacy put up fences or no trespassing signs and gates. HB 1204 would help fix this situation and better protect our property rights. Under it, landowners can make their property eligible for protection against warrantless searches by posting no trespassing signs or similar marks of ownership. If they do, then HB 1204 would require virtually all government officials to either get a warrant or get the owner's permission before they enter the property. This is not, though, applying to anybody who needs to enter the property because of a 911 call or probable cause that there's an immediate need for services or help. That is addressed in the bill and exempted. Those actions are protected so that you're not stopping emergency response at all. It's just saying that without permission from the landowner or a warrant, you can't just wander into people's woods and fields and whatnot for no reason at all. They have to have a reason and get a warrant, or they have to get permission from the landowner. Overall, HB 1204 seeks to restore balance and ensure that landowners in New Hampshire have the necessary protections against unwarranted government intrusion on their property. And I can take some simple questions, but I can tell you that I've got somebody that can answer a lot more questions in depth from a legal standpoint that can also testify.
Just if you could, what did something occur to cause you to want to sponsor this bill?
No single action, but there has been
A court case, perhaps?
This has been getting passed in several states as the situation has become known in other states, and I'm not sure how many exactly, but I can tell you that, for example, Vermont has never allowed open fields. They've always protected the landowner's rights.
Representative Prue.
So I know as a firefighter right now, there's an RSA. If I suspect that there's a fire on someone's land, I have the ability to go look for it.
You could still do that.
Even if it's just illegal burning, somebody burning in a can or something.
Mhm.
All right.
That's protected under probable reason to enter the property.
Thank you.
Representative Mannion.
Thank you, Mr. Chair, and thank you for taking my question. As far as the body camera part goes, there's already an RSA that covers body cameras that I believe is similar to that, but there might be exceptions that are in the body camera law, that might conflict with that. So should that be better left just to that RSA, or?
I would entertain comparisons and make sure that it aligns, but I trusted OLS to make sure that these line up.
Okay, thank you.
As we've already experienced this morning, that could be a
Yes.
questionable decision.
That's why I gave that caveat that
I would ask that you take a moment and just call up that RSA just to compare. So if we need to get, because we're executing this Friday, if we need to amend something, we need to do it pretty quick.
I will make that comparison for
Thank you. No further questions. Thank you. The chair recognizes Mr. Robert Frommer.
Hey, not used to that. Thank you, Mr. Chair, members of the committee. My name is Robert Fromer. I'm a senior attorney at the Institute for Justice, and I'm the director of the Institute for Justice's project on the Fourth Amendment. And I came up to express my support for HB 1204 for really two reasons. The first one is that it's important to understand what open fields doctrine is. This is a creation about 100 years ago out of whole cloth by the United States Supreme Court. In a two-paragraph case, they say, no private land outside the immediate area around your home gets any protection whatsoever under the Fourth Amendment. And as a result, in many states, the vast majority of land is unprotected. Here in New Hampshire, there's roughly 3.6 million acres of private land. 91% of it gets no protection whatsoever from entries. And what that means, and I've litigated these cases across the country. I've interviewed law enforcement officials, other officials who will come on property, not because they suspect anything, not because they think there's anything wrong, but just to see what's going on. They call it patrolling. They'll, in many of my cases, and several of my cases, they haven't just walked on themselves, but they've installed cameras, for the remote snooping, where it would feed back to them, so they'd have a 24/7 view of what was going on. In one case, they did even more than that. They actually went in and stole my client's camera, and then opened it up to see what they could find. Over and over again, I've heard from public officials that with regards to the open fields doctrine, they really don't make any distinction between public and private land. And we've seen that over and over the country. And that's why HB 1204 is so important. This bill is a modest bill that is simply trying to empower New Hampshire residents to reclaim their security in their premises. As the bill notes, all of what private landowners have to do is put up fences or no trespassing signs. There's a number of different ways the bill allows for them to express that they want to keep their property private. And when they do that, and of course some won't, some will, but if they do, what that means is that the vast majority of public officials will have to either get permission to come on the property, get a real warrant from a real judge, or have a real emergency that's going on, an exigent circumstance, we call it under the law. Now, this is pretty modest. A number of states across the United States have rejected the open field doctrine. The representative mentioned probably the most applicable one, Vermont. Vermont wholly rejected the open fields doctrine in 1991, came back in 2018 and said, again, no, we really mean it. Private land means private. If you want to go on it, get a warrant. And, I don't think that the people of New Hampshire view their property rights as any less important than the people of Vermont or the people of New York, who also have rejected the open fields doctrine. And your constitutions look almost exactly the same. They say they protect possessions, and land is a possession. So Washington, Oregon, Montana, Mississippi, New York, Vermont, Tennessee, all these states have rejected the open fields doctrine. And we think this 1204 is a modest step towards improving the security and property rights of ordinary New Hampshireans. That's why we support it, but I'm happy to take any questions anyone on the committee might have.
Thank you. So for clarification, it seems to me what this does is it basically treats all of your property as your house with regard to your privacy. So in other words, unless there's exigent circumstances, police can't come into your house unless invited with a warrant. The same would then apply to your property if you post it. Yes. If you leave it alone, that's your risk to do. Exactly. Is that clear? Is that
that's
right?
Exactly right. And that's the way it is, and that's the way it used to be before the Supreme Court issued its decision. And it's in fact the exact same way in like every other similar country. We're similar to England and Australia and New Zealand. None of them have the open fields doctrine. We're sort of a unique aberration that way.
New Hampshire uses appraisers every so many years to appraise people's property. Would this stop them from coming and doing their job?
Are they going onto onto the private property in order to conduct the assessment?
Yes.
If they get the consent of the property owner as part of the appraisal process, I think there's probably abilities to if you give consent to do the appraisal, we'll be able to then do the appraisal, and it would be more accurate than if we're not allowed access to the property, in which case your appraisal might be higher.
I think we're going to have to check. We may have a conflict in statute if people are mandated to. I'll let you come up in a second then. Okay. We'll leave that one for him to answer, and we'll check. My last question is regarding, what about drones? Now, you're protecting the four corners of the property, but what about the airspace above it?
That's a fascinating question, Chair, because I just had a case before the Michigan Supreme Court 2 months ago It's the first court in the country to consider whether flying a drone over someone's property is a search under either the Fourth Amendment or the state analog. I think it obviously is. It's invading your. You could look at it from one of two ways. From the sense of property rights, it's coming right over your property. It's searching your property. From a privacy standpoint, it's looking at your backyard. It's looking the inside of your house. Ultimately, it's the government using a technology to try to acquire information. And I would argue that when it's doing that, that has to be subject to Fourth Amendment constraints. And that means generally, unless there's an emergency or someone consents, that you go get a warrant. But I don't think that this bill directly addresses that, because this is specifically about physical entries by agents themselves and not about the use of technology. So I don't think this is directly applicable to that particular issue.
Okay, my concern is if we decided to pass this, an agent could walk right up to the property line, float the drone, they don't cross the line, and they could fly it 6 feet off the ground all through the property, and that defeats the bill. So.
Well, that is a very fair concern, and if the committee wanted to amend this so as to prohibit the use of Michigan, for instance, has a statute that says officials can't use a drone to do what they couldn't do directly. So since they can't walk on your property directly, they couldn't use a drone to short circuit that. That similar language could be here to protect against that loophole.
Yeah, that might be a too big a bite. I think that a legislature is going to have to examine how high above your property is your airspace. Because frankly, where I live, planes going to Manchester fly right over my house every day. Is that my airspace? I mean, what? Who knows?
Chair,
Yeah.
I could give you. I know you need to move things forward. I could give you a fascinating multi-hour discussion about this.
I would be
a
interested going
fascinating area.
forward too, because it's growing faster than we can legislate it, and people's rights are people's rights.
Exactly.
All right. Further questions, Representative Rhodes?
Thank you, Mr. Chairman. I just need some clarification.
Sure.
When you were giving your example, you had said real warrants from real judges.
Yes.
What other kind of warrant and judges are there?
Oh no,
Are
I
you
mean,
referring to?
but what I mean by that is oftentimes we'll see court statutes say things like court orders or subpoenas. And what I mean here, and the language in the bill handles this pretty well. The definition of warrant here talks about a court order authorizing a search or seizure that's supported by individualized probable cause and issued by a judge. That's what I meant by it. Not a subpoena where oftentimes prosecutors can themselves write their own subpoenas. So you wouldn't want to have a situation where, oh, we want to protect private land, but if the officer just writes a form, fills out a form saying he now has the power, that sort of defeats it. So that's what I was talking about.
Representative Prue.
When I was up in EDNA, we had a bunch of bills come in for drones. And I know there is some protections already in place on what law enforcement can and cannot do with drones without a warrant.
Representative Stone.
Thank you, Mr. Chair. Thank you for taking my question. In regards to this bill, I like a majority of it. I do have concerns with running Section 5. If Section 5 was to be removed, how problematic would that be moving the bill forward?
Could you state for the committee what Section 5 is?
Section 5 is the government agent equipped with a body-worn camera while entering a secured premise. The camera must be activated and recording the entire time the agent is on the premise. And basically, my concern is same as Representative Mannion's, is we have a section that deals with that specifically, and it might be cleaner to leave that section out of the bill.
I don't think that's a material portion of this legislation. I think it's much better to harmonize this with the existing legislation rather than create a conflict. So if removing this would resolve that potential conflict, I'd recommend that.
I would see that as being a much cleaner avenue to go down.
Thank you. Representative Muse.
Thanks for taking my question. In your opinion, is there a difference between a law enforcement officer wandering around on your property uninvited and a hunter wandering around on your property uninvited?
No. In fact, no and yes. No, in the sense that they're both trespassing. You know, the property law is pretty clear. If I don't have consent to enter and I do that, I'm trespassing. Doesn't matter what hat I'm wearing. I will say it's different though, because an ordinary citizen doesn't possess the unique powers of the state. They can't search, or they can't initiate criminal proceedings, they can't arrest you, they can't, legally shoot you. So there's a unique, while privacy is important, I think the important thing is that people need to feel secure on their property against unwarranted government interventions. I agree with you that trespass is a problem no matter what it is, but when it's an armed agent of the state, that perks my ears up just a little bit more.
Thank you. Representative Muse is referring to another bill that we dealt with last week with the hunting question. And to be clear, both bills say you have to post your land. So if you post no trespassing, you could be a hunter, a police officer, a spaceman. In this bill, you cannot trespass.
Yeah, and that's what I found so useful about the concept of secured premises that was already in New Hampshire law, and it seemed like that was an obvious way to make that distinction.
Representative Newman.
Thank you, Mr. Chair. Thank you for taking my question. You mentioned in your testimony that there was a Supreme Court ruling that open fields
Yes.
Met the requirements of the Fourth Amendment, I believe. I'm adding that. What's the status of that case? Was that case overturned, and does it conflict with this in any way?
Unfortunately, it is not overturned. It was started in 1924. The case is called Hester versus United States. So we're on its 100th year anniversary. Unfortunately, I'm having a celebration this spring. We're having a conference to talk about the open fields doctrine and the various problems with it. But what states have done, a number of states like Tennessee, Mississippi, Vermont, they said, well, we don't really care what the people in the Supreme Court say. We have our own constitution, and it means what we think it means, and we know our people wanted to have this kind of protection. And so they rejected under their state constitutions.
A follow-up. So if this state were to pass that law, they would have to make the same assumption that they just don't have to pay attention to what.
Yeah,
I'm a little bit confused about that.
Okay, sure. So there's the United States Constitution, which handles federal officials and stuff like that. But the New Hampshire Supreme Court is the ultimate arbiter of the New Hampshire Constitution, and it is separate and distinct. And even if the Fourth Amendment allows federal officers to do something like the open fields doctrine, you all have the power to say, as a matter of state law or the state constitution, that no, our state officials can't do that. So that's why I'm saying that the fact that the Hester decision from 1924 is still on the books doesn't prevent state legislatures like yourselves from saying that is too far, that is too low a floor. That is not. I disagree with that holding. I think that is wrong. I think it is bad for property rights, and I'm going to do something more. And you are perfectly entitled to do that both under the Constitution and under legislation.
Thank you.
So for clarification, though, a New Hampshire officer could have or ask a federal officer to look at something for them, and this wouldn't stop them because this would only prohibit New Hampshire law enforcement. Is that your position?
I think that would get into if you're having
actor of the state type of thing.
I think you would run in. I think that would be an attempt to make an end run around this. I think it would end up being a very contested legal issue about whether the federal officer was really exercising his own independent authority or if he's just acting as an agent of the state.
Okay. Any other further questions? Oh, actually, I had one. The Supreme Court has narrowed the open fields doctrine a bit, though, haven't they? Isn't it true that they've extended the curtilage a little bit to places that people routinely use? For example, if you have a shed that's 50 meters back in your yard that really wouldn't be in the curtilage, but if you use it and have an expectation of privacy, have they not extended that?
Yeah, the problem there have been some of that, and it's very case by case specific. The problem is that it leads into, because this reasonable expectation of privacy, oh, it's this balancing test, right? It's like, oh, well, what's reasonable? And it's often very fact specific, and it's often there's no certainty. There's no certainty with it. You simply don't know, because there are courts that have said yes, that would be a search, despite the open fields doctrine. There have been other courts that have said no, that's not a search because of the open fields doctrine. That kind of wishy-washy judicial decision making doesn't provide people the security they need, and that's why I think this legislation is so important. It just says that in no uncertain terms, if you want to go on people's land, get their permission or go get a warrant.
Thank you. One more question, Representative Newman.
Yeah, just following up on your question, wouldn't that more or less be your curtilage? Would that not fall within the curtilage, what you just explained?
Well, that's literally what they say. Like, oh, well, if it's a barn, but if it's closely associated with the things you do, then maybe it's part of the curtilage. But you never know ahead of time what a court's going to say. You can never feel secure on your property because you don't know if the officer's going to think, oh, that's curtilage, I can't go there. And you don't know if the court afterwards is going to say it's curtilage or not. So there's no certainty. And that's why this legislation provides that security, because it just says very clearly, you post your land is secure, go get permission or a warrant. You don't have to play any guessing games like you do with current Fourth Amendment doctrine.
Thank you.
Seeing no further questions. Oh, Representative Sitek.
I'm wondering whether we should wait for the court to come in, or New Hampshire Supreme Court come in on this. And here's what I'm thinking. We have a constitutional right to privacy. Can you, if there were such a warrantless entry and some action resulted from that warrantless entry, could the landowner go to the New Hampshire Supreme Court and say, I have the reasonable right to privacy on my property? I mean, I don't need this law.
Sorry, I apologize for talking. I that is possible that could happen. I will be honest. The reason that this doctrine has stuck around for so long is that most of the time people don't do that. They don't press the legal issue. But there's nothing about the New Hampshire Supreme Court that should give this body any pause about whether to act. Whether it is forbade as a matter, whether entries onto the open fields is forbade as a matter of New Hampshire constitutional law is a separate and distinct question from whether this body thinks as a matter of policy it is a bad idea to let officers roam wild over private land. This body has the power to fix that now. And I would suggest taking that step now rather than kicking the can and hoping that maybe years down the line, maybe somebody will challenge this issue, while all the while real New Hampshire residents are still suffering from the loss of their property rights.
I believe the representative is referring to a recent adoption to our Constitution regarding privacy rights. However, we still have in our Constitution the equivalent of the Fourth Amendment. So is it not possible that the court would see that as separate and distinct from the search, but since we didn't amend the Fourth Amendment, we added this thing.
Yeah, and I believe that's Section 2B, and I believe the search and seizure provision is either Section 19 or Section 20. Yeah. And from what I understand about the legislative history around 2B is that it was more about informational privacy. I think that the search and seizure provision of the New Hampshire Constitution, which uses the term possessions, which by all counts includes land, should already be doing this for New Hampshire citizens. It's just not. But you guys don't have to, this committee doesn't have to wait years to see what the court does. You can take action now to fix it.
Representative Stone.
Thank you. I have a two-part question. The first part is, in your opinion, does New Hampshire, under law, as well as the New Hampshire Constitution, provide a higher bar for privacy interests in the state of New Hampshire?
Could you say that one more time?
In other
please?
words, do we set privacy to be a higher bar for search and seizure in New Hampshire?
Generally, unfortunately, I would say generally not. I believe that the New Hampshire courts I'd have to go do a deeper dive as a matter of constitutional law. I think it's pretty much flattened to the Fourth Amendment standard, that there isn't a lot of, this is an area where the Supreme Court should do more work, but right now I think it's held the two to be at equivalent levels. So I don't think there's greater protections. Well, actually, now that I say that, I think the addition of 2B, it probably provides a judicial gloss that will lead to greater recognitions of privacy going forward.
And the second part of the question is, under this provision of this bill, if it was to pass, nothing prevents a police officer or government agent from seeking out the addition of the premises listed here in articulable suspicion when seeking out a warrant.
But in
In other words, if you wanted to do the field, you'd have to articulate in the search warrant why you wanted to search the field.
You'd have to say, like if it was, if you'd have to say, you'd have to do investigation, just like officers have to do with crimes of all other sorts. You'd have to provide, when they want to get a warrant to go into a house or to a business or anything like that, they have to provide all the information, submit a warrant, and you get approval. And that's all this bill's trying to say, is let's make that across the board, and let's include private land in that as well.
Thank you.
For my clarification, I think what he's asking is, when you get a search warrant for someone's house, you have to be specific as to where you want to search and for what items you want to search. Would this apply then to the open field? I want to search in the back 20 yards of the property where I suspect there may be X, and that is what I'm looking for, and that I want to search. A search warrant wouldn't just say you have access to the property, walk around.
A core element of the Fourth Amendment and the New Hampshire search and seizure is that warrants have to be specific. They're not supposed to leave discretion to the officers. And so, a warrant in this kind of situation would, to the best of your ability, say, I believe at this location on the property, I'll find whatever.
Okay. Representative Muse, did you have a question?
I had a question about how we're protecting privacy in this bill if we require a law enforcement officer to have his body camera on the whole time he's on the property.
Well, that was mostly in the instance, well, if there's consent, right? If there was consent, then let me go back. I think that was the part of the bill that, I think that was the part 5 of the bill that was, people were considering rejecting. It says if he's equipped with the body worn camera when entering a secured premises. So if he's there by consent, then the person's consented, so there's no privacy issue. And if they're there because of a warrant, they got a warrant, then a neutral judge has already decided that there is probable cause of some violation of law occurring such that it's reasonable to infringe on that privacy. And so I think I'd be fine with Section 5 being removed from the bill in sense of harmony, but I don't think it necessarily undercuts the idea that people want security and privacy in their private land.
Follow up. What was the role of your organization in the drafting of the bill?
I helped draft the bill. I've spent years working on this sort of work. I've read the legislation from across the country, the court cases from across the country. Representative expressed a desire to do something in this area, and we talked, and I gave him some advice, and we helped him put this together.
Thank you.
Thank you. Trust me, you're not alone. Representative Wheeler.
Thank you, Mr. Chairman. Would you believe that a person who has a warrant going on for their property would want whatever the police are doing on that property to be filmed so that they know what is happening for the police search, and that might be why the body camera piece is in there?
It's possible. I feel as if I'm in a cross conversation about this issue. I can see valid reasons both to not want cameras, but to want cameras.
That's fine. We'll save that for executive session.
Okay.
Representative Newman.
I just have a question about the conversation that's going on. How does this bill affect a person who is under investigation and doesn't know it? and then the police want to continue an investigation, would they be able to do they have to present a search warrant to walk on any part of their land if they're under investigation? How does that all fit in with this?
So you're saying like this bill passes and then the police suspect somebody of something wrong. And the question is, can they enter his land without a warrant? No, they would have to either get his consent or a warrant. The fact that he's under investigation, I mean, that's part of the getting a warrant is part of the investigatory process. So I'm not sure I understand.
Your question?
No, that's basically my question. I mean,
Okay.
if you apply the same requirements for a search warrant when the Supreme Court has already, the reason it's called open field is you don't have an expectation of privacy in an
Yeah.
open field.
Right. That's what they said.
So the Supreme Court has said that you can't expect privacy far away from where you live, and there could be a legal activity out there. So
Yeah, so
I
this
just-
would
I-
extend that policy.
I don't know that much about search warrants. I don't know if a judge could say and could override this somehow. I don't know.
No.
That
Well,
would be-
he
it
could
would be a
issue a
warrant,
regular
yeah.
warrant saying, I think there's probable cause for you to enter. But I'd point out that none of the other nations with our similar history, England, Australia, New Zealand, none of them have this. This was a constitutional error by the Supreme Court that's existed for 100 years to the denigration of all of our property rights. And that's why I've spent many, many years of my life trying to fix this. And that's why I think this legislation is so important.
Thank you for your testimony. Chair calls Chief Kevin Walsh.
Good morning. My name is Chief Kevin Walsh. I'm the police chief for the town of Rye, New Hampshire. I started my career in law enforcement in New Hampshire in 1987. And just to give a brief outline, the way New Hampshire does it, a lot of areas around the country are going to start to follow, which is all the police officers get trained at the same academy. That includes on search and seizure. So back in 1987, first day of class for search and seizure, a person's property, person's home, is their castle. That's what all the police officers in New Hampshire are learning. So when we see a sign for no trespassing, and there is not exigent circumstances, that requires a search warrant. Some of the things I listened to in the testimony by the two gentlemen are not accurate with New Hampshire law enforcement. That doesn't happen. They're talking about things that happen in other states. And other states are now looking at New Hampshire law enforcement, our academy, and how we're training our officers and what we do. I've been a police chief since 2006, so right around 16 years. I've had some oversight with different officers in different circumstances. And the circumstances that these gentlemen are describing, a search warrant's already required. I don't understand why this bill is necessary. Our courts, as a matter of fact, do those rulings and take care of people's property and their persons specifically to make sure that when law enforcement are doing these searches are accurate. If there isn't exigent circumstances, there isn't evidence of a crime that isn't going to be destroyed prior to getting a warrant. The other phrase I learned as a police officer in 1987, when in doubt, get a warrant. And that's what the officers are trained to do at one police academy. It's reinforced with policies and training. As you can see, I am wearing a body-worn camera. Our department just started that. We're about 6 to 7 months into the program. The body-worn camera is to be worn. We let people know that you're being audio and videotaped. If we're going into private homes for a call for service other than a domestic violence or something that requires evidentiary value, we turn it off at the homeowner's request. We let them know that it's on. So a medical aid call, I would go in. I would let them know I'm wearing a body-worn camera. You'd be an audio and videotaped. I would turn it off for their privacy. Again, person's home is their castle. I have no business doing that unless I'm doing something specific of a law enforcement reason to have the camera on. Police officers in New Hampshire do respect people's property and their person. Trust is the most valuable thing you can ever earn, and law enforcement realizes that we're on a trust mission, We need to continue that bank account of trust. The gentleman to my right, when they're talking about things in other states. I'm confused. It's not happening here, so why are we doing this? Someone brought up, is there a single instance in New Hampshire that you're talking about? They said no. I found that extremely compelling as to why this bill shouldn't even move forward anymore. And as far as the town assessor, yes, they do go on properties and take a look at the curtilage. They're going to be looking for required permission. If there's a no trespassing sign, it is my understanding the town's policy that hires a private company, they do not move forward till they get in contact with the property owner. If there is no sign, they'll take a look outside the curtilage. They will knock on the door, ring the doorbell to see if they can permission to look in. These are the practices and standards that we're already following. So again, I have no idea what these two gentlemen are talking about. I don't mean any disrespect to them, but that's not what's going on in New Hampshire.
Thank you, Chief. If that's what's going on in New Hampshire, what would be the harm in passing this bill? If you're already doing it, would it impact you in a negative way, or law enforcement?
I think it would, and I'll give you a circumstance. I was a young officer. We were called for a 911 call for a domestic. I got there. It was an apartment building, 4 apartments, not a thing. It's 1 o'clock in the morning. We left because there was no obvious signs, and it says no trespassing. So we don't go up on the porch and knock it on the doors. There was no other than the call. We got called back a second time. So that draws in the suspicion that something's going on. I had an officer drop me off. I stood at the side of the house out on the public way on the sidewalk and waited for the third call, or what I heard was a domestic assault going on, or an assault inside the house. I knocked on the door, person came out, closed the door. No need to go in, everything's all set here, officer. I had to call the other units down, we had to make our way in, and it was in fact a domestic assault that was ongoing. Those trespassing signs are going to be a hindrance and prevent us from doing our quality of life to other people. And what I find most disturbing about this is that there is not a single instance that's specific to New Hampshire as to why we're putting this in. Our system already works. I don't understand why this would even move forward. And it is going to be a hindrance to it because there's other levels. They're talking about government. There's the assessors that evaluate property. They're working for a town. They're working for the government. They're out doing their job to do the assessing. They do respect the signs. You talk about hunting. You know, we advise people based on hunting rules and trespassing that they need to post their land 300 feet apart with the signs if they do not wish to have people hunting there. Drones, that was something that did come up. I know there's some cases as a law enforcement officer, if we're going to fly a drone over somebody's personal private property, their castle, we get a warrant because we have time to get it if it's those circumstances. Unless there's exigent circumstances, we don't go on people's property, and we have to articulate that specifically.
Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question. I'm looking at line 23. It says, upon entering private land, a government agent shall immediately notify the landowner, leasing, or occupant if notice can be reasonably made. And it's talking about if there's an extenuating circumstance. I know, I can't help it. Is that something that is already done, or how would this conflict where it says shall if it can?
The officers are already doing it, at least from what I've experienced in my 37 years as a police officer. However, there are other circumstances where this is just going to contradict what we're actually doing. And again, I'm going to remind the committee, you asked the most important question here. Is there a single instance of why we need this bill? I mean, it's like we're just making laws to make laws. We already have best practice standards. We have constitutional laws that are in place, and those best practice standards in writing, in training, are being followed based upon that.
Representative Newell. Representative Muse. Representative Wheeler.
And thank you for taking my question, Chief Walsh. You had mentioned that the legislation would hinder your ability to go into a domestic violence case where there were 4 apartments. But I'm looking at line 20 here of page 1, and it says to respond to exigent circumstances such as a life-threatening emergency or another immediate threat to public safety that was either reported to the agent or the agent personally observed. Would you then say that you personally observed the domestic violence case, which is what you said in your account, and therefore under this law would be allowed to enter that case and deal with the domestic violence case as you see fit?
Under this law, I can see a defense attorney filing a motion that what I was hearing was inaccurate. So therefore, if fruits from the poisonous tree, again, something I learned the first day at the police academy on the search and seizure, if the court would rule that what I was hearing as being an assault was inaccurate and I was guessing, this law would help the defense to have anything we saw after going to that door to be thrown out, and therefore none of the evidence of the domestic assault would be able to be entered into the court. And again, we're letting the victim down.
Can I get a follow-up, Mr. Chairman?
Yeah.
Thank you. Appreciate that. So I will leave that for then, and you and I can discuss about that after. I don't want to debate you. But my follow-up is, you said that the police standards and training already train the officers to do a lot of what's articulated in the bill. I think the chairman already asked a similar question, but if it's already articulated in the in police standards and training, what's in the bill is already in the rules, and they're already trained to do that. None of us live forever. None of us work forever. Wouldn't you see it as a good thing based on the fact that Skippa and his great training, you and your great work for your department might not always be there, and there might be an officer somewhere down the line who has less of a level of respect for the private property rights of our citizens here in New Hampshire, less of a respect for the community as you do, and might end up doing what's outlined here in this bill? Can we rely on the training standards is what my question really is.
That's a very good question. Since 1987, these standards and practices have been in place, and we've improved on it based on what we've learned from people and court rulings. And after I'm retired, these same standards of best practice are going to be in place. And when myself as a department head has an officer that would not be following best practice standards, we have internal mechanisms in place that we're following to ensure either they can respond to the training, and if they can't, then we thank them for working at that agency. And one of the things that I think everybody's aware of, we're pushing forward for state accreditation. My agency is one of them. We're looking forward to being one of the first. And that is, to answer your question, we'll have those best practice standards that after we're all retired, hopefully on a beach somewhere, these standards will be followed because they're in place. Thank you.
Representative Stone.
Thank you, Mr. Chairman. Thank you for taking my question. In your experience, have you found that search and seizure training continues based on different court cases that come down, or is the basic training you receive at the academy the only search and seizure information that you gain throughout your career?
A good question. It's based upon everything that comes down from the courts. We adjust that training to meet those standards. So we know that courts are ruling in a certain way. We need to adjust policy and training with that.
Follow up.
So you're talking about in service, you have yearly or updated trainings?
Yes.
And follow-up question. So if this bill was to come law, that would be part of the new training?
It would have to be, yes.
Thank you.
Seeing no further questions, thank you for your Representative, go ahead.
Thank you so much. And thank you for, you said you're going for accreditation. Is that through CALIA or another organization?
State of New Hampshire state accreditation standards.
Okay. Thank you so much.
Thank you.
If you'd like to know more, I'm on the board. Any further questions? Seeing none, thank you for your testimony.
Thank you, everybody, for taking my time.
You, Representative Popovich Miller, am I saying that right?
Thank you, Mr. Chair. My name is Daniel Popovich Miller, and yes, due to frequent practice, you are doing great at pronouncing the last name. I'm gonna be very, very brief, and I just want to state really that relying on the constitutional protections is all nice and good, but they do leave a lot of gray areas, and a lot of reasonable people disagree on what the interpretation of a particular constitutional provision is. It is better to just have a clear law that the legislature sets the standards needed to get onto private land. And I'm finding a bit conflicted when hearing testimony that says, really, we are already doing all this, but then if you pass this law, we won't be able to do some of the things we are doing. You can either have your cake or eat it, but you cannot have your cake and eat it too. Either the legislation already follows the standards and then there is no harm in passing it, or it requires them to change what they're doing, in which case there is a clear need to pass it. So, you got to just pick one. I appreciate the references to the training and standards of the police, and I'm grateful that they are high. They may change over time. I don't want to rely on that when the legislature can set the clear standards. And plus, officers do not always act as trained. We are humans. We make mistakes. This is good legislation that is needed to clearly spell out the protections we have, and I would encourage the committee to support the OTP motion. And I'm done. Thank you.
Thank you for your testimony.
Thank you.
The chair calls John Garrigan. Department of Labor.
Good morning. My name is John Garrigan. I am the General Counsel at the State Department of Labor. I don't appear in support or in opposition. We are neutral on the bill. However, the department's review of this bill has raised some concerns for us as relates to our ability to enforce and inspect and regulate labor laws as here in the state of New Hampshire. One of the ways that we enforce labor laws is through inspections of workplaces or of elevators. If you see little certificates in the elevator when you come up and down, or of boilers and in other instances. That ability of the department and its employees to do that has been codified in labor law in RSA 273, RSA 275, and others. That authority has existed fundamentally since 1911 in order for us to protect the workers and the public here in the state of New Hampshire. In the review of this bill, the language in it is very broad. It applies to all government agents, not just law enforcement officers or investigators. And so it could be that this bill would stymie or limit the department's ability to enforce or to perform inspections of workplaces, private workplaces, or of locations of, say, boilers or elevators in order to inspect them or to ascertain if violations are occurring. One of the important parts of our ability to inspect, one is to see the workplace as it is, and not in a state where an employer has been able to amend or to change. For instance, perhaps there are youth labor law violations if there are children working in hazardous occupations where they shouldn't be, or other such things. So the bill does exempt the fish and game officers or fish and game personnel in their enforcement of wildlife regulations. Our recommendation would be to have the bill also exempt labor inspectors or the enforcement of labor violations or just regulatory inspections for that regard.
Does your department have any cause ever to do inspections or investigations on the property that's related to single-family homes?
I don't like giving absolute answers, but no,
As close as you can get.
It's yeah, sure.
Barring a home that's under construction.
Labor in the state is performed in a variety of locations and situations, I'll say. So it's not outside the realm of possibility, but usually we're talking about construction sites. We're talking about commercial establishments, but there are times where that could come up depending on how the employment situation works or how the workplace works.
Okay. Representative Stone.
Thank you, Mr. Chair, and thank you for taking my question. When you show up to do a spontaneous inspection, do you announce that you're there with the officials that have control of the premise?
My understanding is that's the practice. Yes.
So you just don't slither into someone's place of employment and kind of say, "Hey, I got you."
We don't slither.
Okay, thank you.
To the best of your knowledge. Representative Sitek.
Does the Labor Department inspect home elevators?
No. That's an excellent question. Thank you.
Do you know where I can get a home elevator? Seeing no further questions, thank you for your
Thank you.
testimony. Is there anyone else wishing to testify on this bill who has not testified? Before I close, I would, a question for the sponsor and your person who helped you with this. If you could, in the next 24 hours, get us some New Hampshire cases that have had to do with search and seizure under the open fields doctrine. We heard testimony that there's no cases, it's being done, it's not being challenged, there's no problems. If there are, we'd like to know, and if not, that's important to know. I hereby close the public hearing. 1276, it's 10:30, we're already late. With that, I open the public hearing on House Bill 1276 and invite the sponsor to introduce the bill. Actually, I'll explain why I like it after. I know. It's just extending you. I don't think it's okay that cops can just traipse.
Thank you. Yep. Thanks. Committee. Your number of you probably are looking at this going, didn't we just pass that last year? And yes, we did. Your committee did pass it, and we passed it out of the House. And over in the Senate side, they said, we want to see it only apply to people who are over 18, which was missing from that. And instead of amending it, they killed it and asked me to put it in again with the language saying over 18. So what you see before you is the same bill we passed last year, but with the specificity of if you're under 18, you still can't own, sell, possess blackjacks, slungshots, or brass knuckles. That's essentially it. It basically lines up with the way we sell knives of large lengths. Can't buy them switchblades and long knives if you're under 18. So it just basically lines up with that. And if there's any questions, I'll take them.
I was going to start with the same question from last year's, what is a slingshot? But we'll just move on from that. Does this law, if passed, remove any of the restrictions on felons possessing weapons?
No.
Is the current state of the law that I can have all these things if I have a hunting license?
Yes.
But if I don't have a hunting license, I can't have them.
Correct.
Thank you. Further
You can also have all these things if you're law enforcement. Currently.
Further questions? Seeing none, thank you. Anyone else wishing to testify on this bill? Seeing none, I hereby close the public hearing on House Bill 1276. We have actually, we're gonna take 15 minutes before we start the next one. What?
It's his bill.
I'm opening the public hearing for House Bill 1276. No, excuse me, 1539. And I invite a sponsor to introduce the bill.
Thank you, Mr. Chairman, members of the committee. HB 1539 is relative to annulling, resentencing, or discontinuing prosecution of certain cannabis offenses. There is already a process for annulment right now in current law. That process is outlined in RSA 651:B. This bill amends that section and then adds in some new sections which open up the ability for somebody, and those new sections are, let me see here, after 651, inserting after section B-5 the following new sections, which are 651:5-C, annulment of certain arrests for and convictions of cannabis. Despite the fact that this legislation is 4 pages long, I would like to think it is decently simple. The process for annulments that I brought forward here in this bill was because of the fact that the legislature seems to be moving rapidly towards legalization of cannabis. The governor has indicated support of legalization. The Senate has moved more so than it had in the past towards legalization, and we have a bill that's coming before the floor, which I think is 17-3, and we'll be voting on that tomorrow. So I think it's clear, especially given the last few sessions, where we're at with the legalization of marijuana, despite some objections from some of us here. There is an effort to move forward to legalization, and it looks like decriminalization was the first step to what the state will seemingly inevitably do. Given that, and given the fact that we've seen legalization across the country, and I'm a proponent of legalization, I support legalization, but I am concerned with what I'm seeing in other places, Colorado, California, places that don't have as robust an annulment process for people who were convicted of marijuana charges. And I'm concerned that the situation that we're seeing right now with the legalization of marijuana is it's being legalized by the state, so people can sell, buy, or smoke it, while at the same time, people who bought it or sold it or smoked it are incarcerated as a result of that. And I think those two realities operating alongside one another is a travesty of justice and a bit of a moral quandary, I suppose, that I think we should address. And this is, I think, a process by which we could address that. I understand the cost for the agencies in the legislation as written would be high, or at least that the cost would be there. It would require new hearings. It would require petitions. The legislation as it was written requires the department to look proactively at some of these cases, as outlined based on the timeline here. I would be open to amendments on that end, but I do think that the bill as it stands is sort of the golden standard of where we should be moving when it comes to the annulments process. And my direct response to the fact that there is a cost here would be, that's the cost of government. That unfortunately sometimes there is a cost here. We incarcerated these people for decades based on this charge, and it's going to take a cost when we remove that as a crime in our books and need to annul those people's records. That is unfortunately, that is the cost of government, and that does take money and resources, but that's the job that we were elected to do. Mr. Chairman, I could go on for hours about this, but I'll just end by saying somebody's record does seriously affect their ability to get a job, their ability to be a fully functioning member of society without illustrating everything that that entails. And as I said in the beginning, it's a seriously unfortunate situation where we have places all across this country where it's legal to buy, sell, and smoke, but people who bought, sold, or smoked it are still convicted or have a charge on their record, which keeps them from getting a job or keeps them from, again, being a fully functioning member of society. I mean, that's just a really unfortunate situation. And I think on top of that, if we're going to do the state monopoly model, it's an even more unfortunate situation because the state that incarcerated that person for, again, buying, selling, or smoking is now buying, selling the product that it incarcerated that person for. So I think just given where we're at here in New Hampshire, given where the movement around cannabis is, and given how important it is for somebody, if the crime is no longer there, to have a clean record, I introduced HB 1539, and I really appreciate the time that you have given me here today, Mr. Chairman.
Thank you. Couple quick questions. Which offenses specifically will it annul?
It outlines on page 1, or the first page of the text here, and let me find the line here, line 10. So this is 651:B-5 as amended here in the bill, line 10, section C. Cannabis-related offenses means the following: any offense under RSA 13-B.
So
involving cannabis or paraphernalia.
that would go all the way up to trafficking, wouldn't it?
Say that again.
Would that go all the way up to trafficking?
Not on my no. RSA 13-B involving cannabis or paraphernalia intended for cannabis. And in terms of trafficking, any other offense that doesn't have to do with cannabis, and I appreciate you giving me the time to
Sure.
answer that.
No, I mean
should-
trafficking in cannabis. If someone
the
was
selling of cannabis.
Yeah, if someone was selling, 50 pounds, that would be a trafficking, I believe, level offense. Would this pardon trafficking charges? Or
Well, I
not
get-
pardon, excuse me, annul.
Well, that's
Yeah.
I think it would have to be no more than the possession limit, and I think 50 pounds would be over the possession limit as illustrated right now in current law. And
So that's what my question is. Is it, yeah, that's more simple. Would this only annul things that we are about to possibly make legal? In other words, selling a massive amount of marijuana without whatever permission or whoever is going to be able to sell it would still be a crime. So we wouldn't be annulling things that would still be a crime.
Correct. Yes, and it does outline that it is the possession limit is the limit for annulment. And as I said in the beginning of my testimony here, the process for annulment is already there.
Yeah.
This makes it so the 3/4 of an ounce is turned to the possession limit. So it will update itself based on whatever the legislature decides with HB 1633 and the other bills that we have before us. So if the legislature decides to do nothing, then this text will sit there as taking up space in the criminal code book, saying the possession limit, and the possession limit will be the 3/4 of an ounce that we have right now.
Gotcha. Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question, Representative Wheeler. I'm trying to read this very quickly, and I apologize if I missed it. So it sounds to me that this is all on assumption that this will become legal before the current governor leaves office. So is this to say that if it does not become legal, then this whole bill is a wash? Or is it your intention, even if it doesn't become legal, that this still goes into effect?
I don't think that the bill would be a wash if it doesn't become legal. I would say that even if 1633 doesn't pass on the floor tomorrow, that this bill would still be a good thing based on the fact that there are indications politically, and obviously we can't, there are serious indications that legalization could pass this year or in the next biennium. So I think this bill is good. But aside from whether or not legalization passes, this bill is good because having it be no more than the possession limit rather than 3/4 of an ounce, I think fits where we're at here in New Hampshire better given the fact that the 3/4 of an ounce could change so drastically, or whether it goes down or goes up. You know, if we make it 1/4 of an ounce, then the possession limit based on this bill would be 1/4 of an ounce, and you could only annul your crime if it was 1/4 of an ounce. So I think it would be good to have, even if whatever legalization bill doesn't pass in this biennium.
Representative Salik.
Thank you, and thank you for taking my question. So just to make sure that I understand, in this bill, so if there are for the people who are currently incarcerated for marijuana-specific related offenses, can you just clarify for me the process by which they would be released?
I can. Let me find I can give you the piece of the bill that does do that here. Let me just find the exact page. I believe it is on page 4. Thank you. Page 4, line 4. Thank you, Madam Vice Chair. The offense is not eligible for resentencing under this section. Well, that's resentencing. Oh, okay. Well, I think it might be. I was seeing it on page 3 because I believe that it has to do with the resentencing. I think you were skipping to the middle of it. I think I was right when I said it was page 3. And the resentencing piece comes in. It starts here on line 16, page 3. 651:5-D, resentencing for cannabis offenses. And as outlined in the bill, without reading it directly here, essentially, if somebody is currently in prison, they can petition the court based on solely a cannabis charge, the court that they were convicted on, to have that sentence resentenced. And it starts here on line 16, and that chapter goes until line 37 on page 4.
In a second, I have a question to clarify that. So if a person is arrested and sentenced to jail, and it was on a cannabis charge, but it was also a firearms charge, and maybe a couple other things thrown in there, would that not require the court to have a whole new sentencing hearing where they decided what the sentence should be based on the other charges?
I believe, Mr. Chairman, that it would have to be solely a cannabis offense. So if somebody was arrested for a firearms charge as well, then they would not be eligible for annulment under this bill. And that also includes people who, and I did have that in my notes for the initial testimony, I forgot to say that, that includes people who took a plea deal. So if you were going to be convicted for something, took a plea deal, and then it was just a cannabis charge, that would not count for annulment. It would have to be you were convicted for solely a cannabis charge, and then or a paraphernalia charge based on cannabis, and then you would be eligible for annulment. But anyone who was arrested, and there's so much text here, it's hard to while you're at the dais find exactly what I'm looking at, but I know I can find it afterwards because I know it's here. Anyone who is arrested for anything other than a marijuana charge would not be eligible for this.
Representative Saley, your follow-up.
Thank you, and I apologize because my brain is trying to make sense of all of it. So if someone were serving 3 years for a marijuana specific charge without any other charges, they through this bill they would appeal to a judge to be resentenced. Is that what I'm understanding?
Yes.
And with the hopes that the judge would then release them.
Yes. Well, anyone who applies for resentencing, I suppose, hopes that that they get released. But I'm trying to find the exact piece in which it outlines what the court does here, so I apologize. I believe that the answer to your question would be found on page 4, line 26, which says that the court may find that resentencing is in the interest of justice, but that a complete reduction. Oh, I'm sorry, that isn't it. But that is around the same place where it essentially says that the court has the discretion to look at what the sentence would be, and if it's not in the, it does outline in this whole page 4 whether or not if it is in the interest of justice or not, then that petition will be granted.
Thank you.
Representative Bolden.
Thanks for taking my question. I know that you enjoy learning history, and I was wondering if you know of folks who received any annulments or pardons after the end of alcohol prohibition. I know that FDR gave some, but I don't know if maybe there were some at state levels as well.
Oh, it's a great question, Representative Bolden. Actually, I don't know my prohibition history as much as someone who supports prohibition should, I suppose. But I do know that there were some annulments given out. I don't think that there was a federal bill passed in the 1930s that opened up the door for annulments at large. But I know that there is a process by which someone could annul. I don't know when that process came into effect, though. Yeah, thank you.
Representative Muse.
Your mic.
I did have a question about the at the top of your bill. It says the possession limit means whichever of the following quantities is greater: 2 ounces of cannabis and 5 grams of hashish, or an amount of cannabis that's legal under the New Hampshire law for adults 21 and over to possess. Doesn't this bill basically raise the possession limit by itself by making that change?
I mean, I think that without giving you a direct answer, because I don't know that direct answer off the top of my head, I think you might be right. That might be an oversight that needs to be amended.
Thank you.
Representative Stone.
Thank you. Thank you for taking my question. Do you have any numbers for currently incarcerated individuals who are either detained in the New Hampshire State Prison or in county facilities for a sole possession of marijuana?
I do have those numbers somewhere on my phone, but not off the top of my head.
Would you be able to provide those to the committee?
I could.
Thank you.
Is it more than 10
Yes.
that are currently serving just on marijuana charges?
Just on marijuana charges?
That would be annulled under this bill?
I believe so, yeah.
Wow.
Based on my conversations with the ACLU.
Thank you. Representative here at Gathright.
Thank you for taking my question. Actually, Representative Stone question was the same as mine, but I just want to take it a little bit further. Did you actually talk to anyone in the DOC about the conversation about the bill, or about how many people they believe would be affected by the bill?
No.
Okay. Thank you.
Representative Newell.
Thank you, Mr. Chair, and thanks for taking my question. I wanted to highlight, we were talking about, Representative Selig was talking about, the process of review or how that would go about. So on page 3, lines 24 to 29, no later than 90 days after the effective date of this section, the Department of Corrections and the superintendent of each house of correction shall conduct a search to determine all individuals. So that's kind of that lays out the process as far as I'm concerned. My question was, I did receive a call from someone who was concerned about the idea of a related charge that wasn't necessarily for cannabis, but it was part of that process. And I believe what he had said was that he tried to flush it. So it was interfering with evidence or something. Yeah, there you go, destruction of evidence. Would this piece of legislation address something like that charge?
Are you saying, would that person be eligible for annulments based on an obstruction of justice charge?
Yeah. Would the obstruction of justice, would that be part of the?
I think unfortunately that the circumstances in that case would prevent him from being annulled under this bill because of what he was charged with. And I just don't know if there would be a way to allow for annulments of obstruction of justice without getting into much hairier territory than we already are with the cannabis charges.
Gotcha. Thank you.
Appreciate it.
Representative Manuel.
Thank you, Mr. Chair, and thank you for taking my question.
Right in the sun.
I know you've been waiting for it. So I just began slithering through this bill, so bear with me. There was a bet to get that word in there. So we're talking about from when I look, like 3/4 of an ounce, 2 ounces, small amounts for possession. However, we're also talking about people incarcerated for 3 years. Are there a lot of people that are incarcerated for state prison sentences that have small possession charges? Or are we going back to the people who are trafficking the 5 pounds, the 50 pounds? Are those the people that are in state prison? And does this actually apply to them now?
Well, this applies to anyone who gets a charge, so I don't think that there would be any specific application to state prisons. I mean, if you have a charge from anywhere, if you happen to have been in the state prison because of a cannabis charge, then you would be able and eligible for this bill. If you're in a state prison because of sale of 50 pounds of cannabis, and somehow you had 50 pounds of cannabis and you weren't selling anything else, it was solely a cannabis charge, you're not eligible for this bill because you were trafficking in significantly high quality of cannabis, and you were
You mean quantity, not quality.
Quality, exactly. That and that would not be eligible for the bill. Yeah.
Seeing no further
No question
actually,
from Mr. Prue. Mr. Prue told me he was going to get me. Huh?
Representative Murray, would you like to provide some clarity to committee on the possession limits currently as we discussed?
Sure, Mr. Chair. I was just going to say, I wonder if maybe the 2 ounces came from the fact that 2 ounces is the possession for if you have a medical card currently. And then it's, I believe, 3/4 if you don't have a medical card. But,
Well,
yeah.
I hate to look stupid on the dais, but for Representative Murray, I'd be happy to do that. I guess that's what we're looking at here, Representative Muse, is the medical limit there. So I wouldn't support an amendment for that then. Yeah.
Well, actually, so what you'd be, right now, it's a violation if you have more
Correct.
than the 3/4 of an, no, up to 3/4 of an ounce is a violation. Above
Past
that, I
is
believe,
a
is
fine.
a crime. So what this bill would do would make it legal to have up to 2 ounces. That's a big jump from a violation at 3/4. Do you see what I mean?
I see what you mean.
That's a
If the
huge
2
jump.
ounces, if the 2 ounces
Is medical only.
medical only,
Yeah.
we could amend it to say that. I mean, if that.
Yeah, I think the amendment would be that the part that isn't criminal would be the part that whatever is legal for people without a medical card, leaving the medical part out of this whole bill, basically,
Yes.
because they're already exempt.
Yes.
Correct? Okay, so, all right. Representative Stone.
After looking at your bill and listening to your testimony and some of the things that have come up today, I guess this is more kind of a statement, but if you're going to be doing any amendments, I'd be more inclined to support any misdemeanor level offenses versus any felony drug trafficking offenses such as, intent to distribute non-narcotics under 318B. So if you're looking at crafting a bill, I would urge you to take a look at your levels of offenses for annulment.
Representative Stone, I had the same concern, but maybe you'll find it in the bill, but I believe what he's represented to us is that that wouldn't qualify for the annulment, those level of charges. It only would qualify
For misdemeanor below,
yeah, for people with,
and I would support that.
Yeah. Anything, just to clarify, if I may, Mr. Chairman.
yeah, sure.
Anything that is where the possession limit is at. So right now, the possession limit is 3/4 of an ounce. If you have anything over that, it wouldn't apply to
So
this bill.
follow-up is how can anybody be in the state prison for those amounts?
Yeah, well, I'm interested to see what numbers are too, and he's going to get those for us, I believe.
Thank you.
I would encourage everybody to read this bill thoroughly between now and Friday, because obviously none of us have. So it is 4 pages long, but we need to dig into it. Further questions for Representative Newman?
Yeah, I'm just curious, on page 2 at the top of the page, where all of these directions on what shall be an offense and related offense and what they have to prove and go through all of that. I'm just wondering if that needs to be that detailed in the bill, or is there some way you could do it without quite all of that information? I'll talk to you offline.
Yeah, if you could clarify that question.
I'll
Yeah,
talk to you
definitely.
offline.
Yeah.
Although any simplifications would be appreciated. Seeing no further questions, thank you.
Thank you.
Who we got? Chair calls Dr. Hannon, the Honorable Dr. Hannon.
Good afternoon, Mr. Chair and members of the committee. My name is Joe Hannon. A little bit of quick background. I was on the first study commission to study legalization and taxation of marijuana, and back in, I think it was 2018. And I was also involved in writing legislation for the last helping with the legislation for the last several years for legalization. A lot of what I wanted to say was already said, which is great because it'll cut my time down. So that's why I did a little longer introduction. Sorry. You know, jobs, housing. Another thing that was left out was student loans. People, and I have a senior in high school right now. If someone is a conviction, they can't even get student loans for felony convictions on their record. It's very difficult. Housing, all kinds of stuff. So we hear about the harms that drugs can cause, and that's why we have locked people up for so long, and that's our rationale. But we never look at the other side of it, which is how much harm we've caused because of locking people up, taking away their opportunity to have a job, to have a college education, to have a home. These are things that are even more important. And I don't want to debate whether it's worth putting someone in prison or not clearing their record because, you know, they were under 3/4 of an ounce or they had 3/4 plus 0.001 ounces. That would put them over the limit. And now they have to live with this for the rest of their lives. I think it's silly that we're going to potentially profit as a state, like we heard, and that we're still going to keep people held accountable for things that now the state is currently making money off of. I think it's egregious, and this bill says, I think the words are actually in here. You know, there shall be a presumption that the granting the position would be in the interest of justice due to the decriminalization or legalization of cannabis for adults and the unequal enforcement of cannabis laws. That sounds. We've heard people ask how many people are still in jail for these offenses. We have to look at the percentage of people of either minorities, people of color, who have been incarcerated disproportionately. The numbers of people that actually use most drugs and alcohol is pretty much the same. You know, you might have slight differences in specifics about what drugs are used and when, but really the rates for addiction are not that different across racial and economic lines. So because it's been disproportionately enforced, even in New Hampshire, I believe the numbers were, I think, 1 out of 4 times more likely or 4 or 5 times more likely to be incarcerated. I think it's an egregious wrong that needs to be righted. And also our own state constitution says the crime must fit the punishment. So someone who has 3/4 of an ounce should be able to get their records annulled. I definitely agree with that. But should someone with 3/4 and plus 0.001, because that's all you need to do to go over the limit in something. The difference between a drug dealer and someone who just has it for possession for cocaine, fentanyl is 1 gram. If you're 1.001 over, you're now a dealer, whether it was yours or not. There's no, you know, they didn't have to photograph you selling it to a child necessarily to convince people that you were dealing. It's the number. And I think that's it's a very arbitrary and I think ultimately capricious act that we've had in our laws for a long time that I think absolutely must be overcome. And also the fact that this bill, it might have a higher limit for the possession. It's not changing the possession limit necessarily. It's allowing people to have their records annulled for that limit. So someone who may have had an ounce and got arrested years ago, now they may be a medical card patient and they now can have 2 ounces, but that person wouldn't be eligible unless we can raise that number to what they can currently hold. So we don't do this for alcohol. There's no possession limits for alcohol. It's a totally different discussion, but I think if we're going to put numbers on it, we should put the most accommodating number we can to help the most number of people to pursue jobs, pursue advanced education, and to change their lives and right some of the wrongs that have happened due to our past laws. I'd be happy to take any questions.
Thank you. I would say baby steps, but you make sense. My question, though, is regarding, well, I would suggest that if we pass this with the small limits and then we pass that, then it's a different argument. Right now, it's still illegal. So regarding firearms, annulments are not the same as a pardon, in my understanding.
Right.
So someone will still have a NICS record and still be prohibited, even if we annul their records. Is that your understanding?
I'm not really sure. I'm not an attorney, so I don't want to testify on the record for that.
I wish you would tell that to Representative Holt, but go ahead.
Okay. Yeah, Yeah. It does say that they don't have to annul, for reasons of justice. In the interest of annulments would not be in the interest of justice. So that can be proven. It doesn't even matter what the charge is. They asked about selling. Specifically, this bill does not allow for annulment in the instances where someone was selling to a minor or to a child. That is in the bill. I believe it's on page 2, line 30. An adult distributing cannabis to a minor or using a minor to sell cannabis or for negligently storing marijuana-infused products, causing a minor to access them. So even if your kid got into your supply or got into your medicine, that would be something that would not be allowed to be annulled under this bill. And anytime, not just selling it, but convincing another child, a minor, to sell it would also be not annullable behavior. And I think this is a good bill for adults. It still protects children to a very strong degree. And as far as secondary crimes, if someone never had if someone got possession and say when they were 18 years old and they got arrested for that, it's a felony conviction. It's on the NICS system. They can't have a firearm. I'm curious to know what that would mean. Like you were asking, what it will mean federally. But if something's annulled, you'd think that it would never have happened. But I don't know if that's the case for NICS. And also, even if it was, how do you get off the NICS system, which is a totally separate debate.
Technically, I would believe that the agency that submitted the record would have to withdraw the record, but annulment isn't the same as a pardon. It only makes it public facing, I believe, that
Right.
it doesn't exist. So for your points with regard to housing, et cetera, but I believe for law enforcement, the record's still there and it still exists. But I could be wrong myself. That's why I was curious to know if you put on your firearms hat, if that was the case.
Well, if you became governor, you could pardon everybody.
I could, but I won't be doing that. So
Worth a shot.
yeah, Representative Mannion.
Thank you, Mr. Chair, and thank you for taking my question.
Yes.
I'm still confused because I'm hearing conflicting testimony. You mentioned felony level conviction. So would this also apply to not only the person who had a misdemeanor possession charge, but also a felony dealing charge as well?
It would have to be under the limit because drug dealing does not necessarily mean someone was a drug dealer. It's oftentimes if someone has a film of you, if they record you, and you can ask the police, if anyone officers are going to testify, they'll probably know even better than I am. But if someone is in the act of caught in the act of selling, they can say someone's been dealing. But it's often based on the amount. If you look at the RSAs for the penalties, it's based
intent to distribute.
the intent to distribute, right? So intent to distribute would be something purely based on weight or amount. If you're raising the possession limits, then you would have to change that even for felony offenses if it's a small amount. Now, this would not cover someone who had 50 pounds or even a pound. That would be out of the purview of this, unless for some reason they change the possession limits to be equal, to be the same as the alcohol laws, which we have, which you can get a whole truckload of Hennessy and drive it wherever you want.
I think the
I have a
ATF would
follow-up.
disagree with that.
I do have a follow-up on that.
Yeah.
So you were talking about 0.3/225.
Right.
They would be considered felony intent to distribute, possibly.
I have to check.
All right. So my question would be is where do we draw the line there? So how do we know the person in jail for intent was dealing 50 pounds or 1 ounce? We wouldn't know that. So they would all be eligible for annulments according to this bill.
I guess it would. I imagine it would depend on what they were convicted of. If they were convicted of a certain amount, that would be in the court record. I mean, they would have to have the number. If they don't have an amount to even put in the record, then they don't have enough evidence to commit to prosecute someone, I would guess. So, and this is all guess. I'm not, like I said.
I think we need to read through the bill real closely because my understanding based on the testimony is that there would be a court hearing where they would have to introduce evidence, and part of that would have to say, well, look, I only had this much, versus someone trying to say, well, it's something. And I think it's tied to the amount that we legalize. So unless we legalize that amount. So that's why I'm curious about the felony people incarcerated. How can that be if this would only apply to people that have a certain amount? So we're going to have to sort that.
May I add to that? On page 3, line 4, all convictions and arrests for misdemeanor or violation level offenses for possession of cannabis shall be automatically annulled. Within 6 months of the effective date of this section, the Department of Safety shall remove any such qualified convictions from its records and notify the court from which the case originated, which shall place an order of annulment in the court file and thereafter process the file in the same manner as any other annulled case. So for just the violations and misdemeanors, it's automatic. They have to do it. Now you can petition, you can go to the court and say, or the Department of Safety and say, hey, check my record. Is it clear? If not, you can still petition to go to court and have it fixed. This is for any violations, or not violations, sorry, bad word, for crimes beyond the misdemeanor and violation level that would have to be heard in court and potentially for resentencing.
Thank you.
Does that help?
Representative Sitek. Any further questions? Seeing none, thank you for your contribution this morning. Anyone else wishing to testify in this bill who has not done so? Seeing none, I hereby close the public hearing. And 12 o'clock, 15-minute break. Okay, I'm opening a public hearing on HB 1270 and invite the sponsor to introduce the bill.
Thank you, Chairman Roy and committee members. For the record, I am Representative Joe Shapiro from Keene, Cheshire 16. Thank you for allowing me to bring House Bill 1270 involving a small but extremely important fix for our county jails that this bill will provide. I am doing this on behalf of Superintendent Doug Yazway of the Cheshire County Department of Corrections, as well as the other county jails around the state. Prior to giving you the specifics of this bill, let me just say that my request today involves no judgment whatsoever on the corrections practices at the Cheshire County Jail. Having practiced as a social worker in that community for decades, I've had many opportunities to interact with staff and incarcerated people at the jail. And while the jail is far from the best place to provide services for mental health and substance misuse issues, I can attest to the fact that going way back in time, our county jail has been a leader in attending to the mental health and substance misuse issues that are so prevalent among those incarcerated there. The issue addressed in House Bill 1270 is a requirement that has been in statute at least since the late 1980s. And I want to refer you to RSA chapter 172B that I gave out, and point your attention specifically to Roman numeral 3. It says that intoxicated or incapacitated individuals who are brought to the jail for a maximum 24-hour stay for protective custody. So these are people who are picked up someplace by law enforcement. They haven't committed a crime, but they are so intoxicated that they are unable to be safe, or maybe might create a safety concern for somebody else. That the current practice is that they are they can be taken to a county jail, and the county jail has to admit them for a maximum of 24 hours. So if you look at this RSA, you will see that the jail is immediately upon lodging said person in protective custody, the corrections officers must contact an alcohol counselor, a clinical staff person, an approved alcohol treatment person, a nurse, et cetera, et cetera. Basically, it says that anybody who is admitted for protective custody must have an immediate assessment in terms of their medical and substance misuse needs. So this is far beyond what is required for somebody who is brought to the jail by law enforcement because they are charged with a crime. And many of the jails, Superintendent Yazway just told me that more than half of the jails do not have nursing or other medical staff or substance misuse professionals that are on staff 24/7. So essentially, this has been a requirement that has not been complied with for decades, which is not really fair to the incarcerated people, but it is also creates tremendous liability for the counties and the corrections departments within the counties. It also is not it's not parity with people who are arrested for a crime. So really the focus of this bill is to remove that requirement. While we do not want the county corrections departments to be saddled with an impossible to comply with requirement, we want to make sure that this change in no way compromises the safety of those who are housed for protective custody. Therefore, we have added a stipulation that if in the judgment of law enforcement
or the corrections admitting staff, there is a potential life-threatening emergency, then there will be a request that the delivering police agency have the incapacitated or impaired person cleared by a hospital emergency room. This is not my area of expertise, but I am told that cooperatively these decisions are made all the time, only in the case when there's a life-threatening emergency, and this is standard practice. I mean, there might be people who testify who say that's the case, and there might be people who testify saying that's not the case, but that is my understanding. Our initial idea was to have everyone who was coming for protective custody be cleared by an emergency room. And in retrospect, that was not a good idea. I mean, the emergency rooms are already overwhelmed. These people would be more prone to being uncooperative than other people. And not everyone who is drunk or incapacitated by drugs is really having a life-threatening emergency. So thank you for giving consideration to House Bill 1270. While I'm not wed to all of the specific language, and there's some additional language that kind of codifies the process by which law enforcement ends up bringing someone to the jail, like that they might check with family first, or see if there's a friend who can take that responsibility for that person. If any of the other language that we've tweaked is a problem, I hope that once this committee has the bill, that they will focus on Roman numeral 3 of section 172B:3, which is a longstanding problem for our corrections agencies to not be complying with our own laws. Thank you, and I'm willing to take questions, although I know Superintendent Yazway from the Cheshire Department of Corrections is here, and he might be able to answer technical questions better than I.
Thank you. In reading the statute, I maybe have a different take on it. Your law or proposed law deals more with, covering whether there's a medical emergency or a problem with the person. My reading of the current statute is it was more of a civil rights issue where the person would have to be, in other words, so that the police couldn't just say, I'm taking you for protective custody because I think you're intoxicated, and the person would be sober and say, wait a minute, you're just doing this to harass me. This says here, because it says they will determine whether said person is indeed capacitated. So in other words, it looked like a check on whether or not someone needed protective custody versus whether or not they needed medical help. So I guess my question is if we remove that language, is there any check on ensuring that someone put into protective custody because they're intoxicated actually needs the protective custody versus just someone doing that to them? And I have to read the protective custody statute in full, but it seems to me other states offer a breathalyzer or something of that nature to prove intoxication, but I think we can discuss that with law enforcement. Do you have any thoughts on that? Mike?
That is a very good question, and I've never thought about it from that angle. And that in part is because it was brought to me with a different interpretation. And so I would have to really think about that and look at that more myself.
Okay.
We certainly wouldn't want people, to be sent to the county jail as some kind of punishment because they weren't getting along with a particular police officer.
Right. Thank you. Questions? Representative Newman.
Yeah, just a question about, are you saying that intoxicated or incapacitated is removed by the bill? And I'm not sure that I see that.
No, I think that the having a medical professional determine that is what's removed, isn't it?
It's still in there, but it has, thank you.
Yeah. The chair calls Sheriff Bill Wright.
Good afternoon, Chairman Roy and the members of this committee. I'm Belknap County Sheriff Bill Wright. I am currently the secretary of the New Hampshire Sheriff's Association. I'm representing the Sheriff's Association today. I'm testifying in opposition to House Bill 1270 as it's written relative to protective custody statute. A few things that I look at and that we looked at with House Bill 1270 as introduced, it draws some questions as it relates to local jails being removed from the first section in talking about allowing county correctional facilities as the lodging. So places like Nashua and Manchester, where they actually have holding cells that they could be considered jails, that part would be removed, which we don't think is appropriate. The bill is absent definitions of what potentially life-threatening medical emergencies means. Is that the amount of BAC? Is it the intoxication of drugs or a specific kind of drug? Is it high blood pressure, abscessed tooth, skin infections? These are all things that we, when we bring people into the jail, we get turned away for and asked to get medically cleared for incarceration. So during a protective custody hold, which is no more than 24 hours and typically no less than 4 hours, this would not be a good use of law enforcement to be doing medically cleared for every incident that may arise. High blood pressure, I bet if you check my blood pressure now, it's probably up. So, again, I don't need to be cleared from medically cleared for that. There's a removal of Section 5, which allows the refusal of the jail and correctional facilities to accept intoxicated and incapacitated persons. Right now, when we make the request as a law enforcement official to hold this person for that intoxication or incapacitation, traditionally they're accepted. This would remove that right that it could be arbitrarily refused. Section 8 was removed, which dissolves any type of immunity, if you will, as it relates to this particular bill, and it takes it out of the. So it basically puts the civil and criminal liability in the hands of the jail and the officers. So I don't know why that would be removed. Another thing that we looked at was the usage of emergency department, so the ED or ERs. Officers and deputies, when they're turned away at the jail or correctional facility to get somebody cleared, medically cleared for incarceration. Again, some of that could be a pre-existing issue, different infections and things that they have on their skin. We end up spending a lot of time up at the hospitals trying to deal with getting them medically cleared. Now, remember, if it's a skin infection or some form of issue that's medical, like a abscessed tooth or something, we get put at the end of the list as real emergencies come into the emergency department. So that's a concern for us. Not to mention that we have departments across the state that are rural. When they travel 20, 30 minutes to the local jail, or in cases like Plymouth, where they actually have to drive to Grafton County, which is well over an hour, when they arrive at the jail for this intox, they get turned away and told, hey, you need to go and get medical clearance. Our concern is that it's a security risk to continue to have these people out and about. It's a risk to the public. It's a risk to the emergency staff as well as law enforcement. We also take into consideration how much time our law enforcement is actually off the streets dealing with some of these issues. We have local jails that are designed to hold people, custody and control. Your local law enforcement officer out on the streets, that's not really their function, to maintain these people in custody and control for lengths of time. The PDs are not designed for that, nor are the police cruisers, so on and so forth. I did want to read the definition under Chapter 172B1, specifically, intoxicated means a condition in which the mental or physical functioning of an individual is substantially impaired as a result of the presence of alcohol in their system. Incapacitated means that a person, as a result of his use of alcohol, is in a state of intoxication or mental confusion resulting from withdrawal such that he appears to need medical care or supervision by approved alcohol treatment personnel as defined in this section to assure his safety, or he appears to present a direct, active, or passive threat to the safety of others. Now, we have a lot of public events that happen across the state, different venues, where alcohol is either served or consumed, sometimes in large quantities. And law enforcement is forced to deal with some of these people. We have learned that you cannot reason with somebody who's intoxicated or incapacitated. So we try to do everything that we can in our powers to find them a suitable person to take custody of them. Normally, it's an adult over the age of 21. When we're not able to do that or able to find somebody in a short period of time, again, we're not going to wait for somebody to come from Massachusetts to go to Plymouth State University to pick these people up. So we bring them to our local jails for that duration. We need to be able to do that, and we need not to be tied up with bringing these people to the hospital to check what their BACs are and all that. It can be easily done at the jail. That'll conclude that. I'll take questions.
What is the, I mean, is there a cost to the county for these medical exams? I mean, if these folks don't have medical insurance, who pays the bill when you bring them in there for all these clearances?
I can't say that we've ever received a bill at the county level, so I can only say that either they do private insurance if they have it, or through Medicare or Medicaid, whatever they normally have.
Okay, because we've heard from other sheriffs that have had people that, not PCs, but people that are incarcerated for, a year or more, and they're responsible for their medical bills while they're in there. So I wondered if that applied here as well.
I don't believe so, because these people are not technically committed.
Okay.
So there's no court ordering these people.
Yeah.
And by definition, it's not intoxication. PC is not, so protective custody is not considered an arrest as it relates to criminal charges and things. So I don't believe that the county would be on the hook for that.
So the person then would be on the hook for the emergency room visit that you guys brought him to for whatever test they decide to do. They would end up getting a bill for that.
Yes.
Can you speak to what the Cheshire County Sheriff, I assume that you folks talk, that they seem to be having an issue that they asked for this bill.
So I have not personally spoken to the Cheshire Sheriff about this.
Okay. I just thought as the Sheriff's Association, you might know.
The majority of the Sheriff's Association are the ones that discussed it and determined that this would be appropriate.
Thank you. Representative Newell.
Thank you, Mr. Chair, and thank you for taking my question. I'm wondering, I'm sure that there are some differences between counties and facilities in different areas, and I'm wondering if is it that the facility that you run has the capacity to be able to do this, and maybe it's not, that's not a possibility in all cases?
Well, I can't speak for what they have for housing at different counties. I know that when we're bringing people to a jail, a county jail, if that jail was full, let's just say, that the superintendent has the ability to ask for the person to be transported to another jail facility. So we do this, and we do this here in Belknap County because of Bike Week. So Motorcycle Week, we basically emptied our jail and have it available for our event that's going on.
Can I follow up real quick? So specifically what I think is trying to be addressed here is medical clearance, right? And so I'm wondering if, it would seem that would, in order to be able to have that in your facility, in each facility, which is something that you would think is a time-sensitive thing, right? You want to make sure that somebody is okay to be, in custody, right? Is there the capacity across the board in all of these facilities where there is someone who is available at all times to be able to do that, a medical professional to be able to do the assessment?
I don't know what other jails have for medical staff or what their capabilities or competency is. I cannot legitimately answer that.
Okay, thank you.
Sheriff, if you would, for the benefit of the committee, take us through a typical PC from your end. You're notified by a law enforcement department, hey, we're coming in with one, protective custody. What happens?
Well, normally it starts, I'll use the Loudon Racetrack because we work down there on occasion. And, we'll end up getting either a call to identify somebody who's being disruptive. Once we make that identification of them, we talk to them and we determine whether or not they're intoxicated or impaired to some degree. Most of the time, they're impaired to the point of intoxication or incapacitation, and at that point, we try to get somebody to take custody of them at that point and get them back to where they need to go. When that fails, we end up having to take them into physical custody, and then we transport that person to the local jail and fill out the detainer request for a hold for intox. While at the jail, they traditionally will do a breath test, a preliminary breath test, and it'll come up with some form of result to show that they're not having a medical issue as it relates to like diabetes or something that presents like an intoxication or incapacitation. As long as that shows that they're, over the normal 0.08 legal DWI intoxication impaired BAC, they'll accept them in, and then normally that's they get held for 4 hours or more, depending on their intoxication level. Nothing prohibits the jail from continuing to make phone calls or allow the person to be released. Again, we've had times where we've had people that were completely inebriated, and that we brought them to the jail, and they called somebody from another state like Massachusetts, and the family member came up and took custody of them. So that's been the normal process.
What about medical screening?
So the jail does their own medical screening. Those of us who work in the streets, we don't traditionally do any form of medical screening unless there's obvious illness or injuries, something that needs either immediate attention. On occasion, we do take people into custody that are intoxicated. They don't want to go to the jail. They start hitting their head off the cage of our car and end up splitting their forehead open, and then we need to divert to the ER in order for them to get bandaged up. So that does happen on occasion.
Thank you. Representative Stone.
Thank you, and thank you, Sheriff, for taking my question. You mentioned you cover Loudon, and you also have Bike Week. How problematic would this bill be for your department operationally if it was to go forward with your course of doing business during those high volume times?
Well, I think it would be very problematic. It would take deputies deputies and officers off the road for extended periods of time to get hospital clearance for people who are intoxicated or incapacitated. To some degree, that ultimately, when we get to the hospital, we utilize these resources, and we get told the same thing every time, that there's nothing really you can do. You got to let them sober up. It's all about monitoring the person and making sure that they're not vomiting and aspirating on it, or that they're being monitored. So, and that's what, again, jails are designed to be a constant monitoring, and they have they're a lodging facility.
Follow up. In the course of Motorcycle Week, what's the volume that you're familiar with being taken to the jail in regards to either protective custody or intoxicated individuals?
Well, I've been at the sheriff's office at Belknap County now for just over 18 years. And I can tell you at one point we had 150 people that cycled through the jail within a week. And other times we've had 20. It all depends on the event and the weather and all that. Now, I mentioned Bike Week, and I mentioned NASCAR. I know that we have a captain here from Guilford that will probably testify to Meadowbrook, which can bring in a significant amount of people. We do PSU for their spring flings and things. We've been out to, we had Pumpkin Fest out in Keene that we participated in. So we've traveled all around to help support local law enforcement. And so we're not just centralized to one specific area or one specific event, but again, we do encounter people when they're in these mass groups, and they're there to have a good time. And sometimes as they continue to indulge in alcohol, their ability to make good choices sometimes goes bad. And we take them into custody again for public safety and to make sure that there's no disruptions.
Thank you.
Sheriff, isn't it in a way better for an intoxicated person? I mean, in a lot of these cases, couldn't you also charge them with disorderly conduct? And instead of doing that, you kind of cut them a break and put them in protective custody. So if this were to pass, you may end up having to charge more people with disorderly just to not have to deal with all that. Is that true or no?
Yes, that's true. We could charge people with disorderly conduct. We could charge them with inciting riot. There's other charges that we could most certainly go with. Sometimes we have people who are not so cooperative in being taken into custody that we could probably charge with resisting arrest, but we really try to reserve those for people who really need to be charged with that and to be heard on that. So we try not to do extreme indifference with these people. We try to, first thing that we do is we try to get them a sober person to come take custody of them. We most certainly don't want to go through the paperwork of dealing with the, at the jail. We don't want to go through medical clearance. We would prefer to release them to a sober, reasonable, responsible adult and have them go sleep it off wherever they're going to end up. Where it comes into a problem is when they have again, this bill talks about releasing them to a reasonable person. Well, what is the definition of a reasonable person? Is it the 18-year-old child that is required to pick the parent up because they know what's going to happen if they don't? And when they get home, is there going to be additional problems? And normally the officer who takes these people into custody when we get to the jail, we normally tell the people at the jail, the corrections officers, that this person really needs to be held for a period of time. And some of that's as a cool-off period too, depending on the event that may have got us to draw our attention there. Again, we don't just come into contact with people when it comes to intoxication. Normally it's because we've been called there for some form of a problem, or we've identified that there's something going on.
In your opinion, if this were to pass, though, could it result in more people being charged with disorderly and things of that nature instead of just getting the PC?
It very well could be.
Thank you.
And the prerogatives could end up turning into, well, if we're going to get stuck at the hospital for 4 hours, then it's going to be making it worth its while. And people could end up getting charged accordingly. I'm not saying it's right, but it very well could be. It could happen.
Representative Murray.
Thank you, Mr. Chair, and thank you for taking my question. I might just be a little confused, but from my understanding, I thought that it's already a requirement that the person, like the individual being taken into protective custody, is evaluated, and that's like the issue that's trying to be addressed because there isn't capacity for that evaluation to happen in these county jails. Not all of them, I guess. I don't know. I'm just confused about, like, is this actually requiring additional work, or is it just providing other pathways beyond that taking place in the jail, within that 24 hours?
So the jail is supposed to be doing these evaluations within the walls of the jail. So the corrections officers, the people who are housed in that location, that facility, are the ones that are supposed to be causing that to happen. The law enforcement officers that are out on the street, that are policing the streets right now, are the ones that this bill, as introduced, will cause the local police officers to potentially end up spending more time in a hospital setting with these people who are intoxicated or incapacitated, just to get them into the jail to be held. So the question would be is, even if they were being evaluated, who do you want to do the evaluation? The people that are in the position to do custody and control because that's their primary job, or the officers that are the law enforcement officers that are on the street that are supposed to be out there enforcing the laws?
Okay, that helps me understand it a little bit better. I guess my concern would be, it feels like something needs to change though, because the jails are saying that they don't have, or not all of them have, the capacity to do those evaluations within 24 hours in the jail cell once someone's held. So I guess, is your main concern kind of like the transfer of responsibility being to the officers, and that it should still be housed within the jail system somehow, even if the process changes a little?
Yes. So I believe that there's a separation between the corrections personnel and the law enforcement personnel on the streets. And unfortunately, it feels like, based on this bill, that that it would be pushed on to the law enforcement officers who should be out on the streets dealing with the crimes that are occurring.
Is it true that in some jurisdictions there may only be one officer on during a given shift?
Yes, and in a lot of cases now, especially in like, I can speak specifically for Belknap County, we have a lot of departments that have now gone to on-call status, so they're not even readily available when you call them.
So if that one person is tied up with the medical, nobody's covering the town.
Yes.
Thank you. Further questions? Representative Newman.
Could you just comment further on your objection to the local jail being taken out? I mean, I'm just,
Yes, so there's a section that's currently in the legislation that talks about that lodge the person, and what's struck out is in a local jail or county correction facility, which is a key component to Section C in that. Now it speaks to local jail later on in the bill, but with that strikeout, it makes it sound like that we're going to actually, the way that it reads is lodge the person for said person's protection for up to 24 hours in the county correctional facility or until the keeper of said facility judges the person to no longer be intoxicated. And then it goes on from there. But I want to make sure that the police departments that have the ability to provide their own jail, and I know that Nashua and Manchester have their own holding facility. They have their own booking officers, people who are actually assigned to that location that can house these people for that short duration of time, so under 24 hours before they get released.
thank you for that answer. And follow up. And there's one place where jail is not lined out. So, but those places have the capacity to keep people for 24 hours. Is that correct? Okay.
Yes.
Yeah. Thank you.
See no further questions. Thank you for your testimony.
Thank you.
The chair calls Doug Ayasu. Yazwe.
Good afternoon, and thank you, Mr. Chairman and committee members, for hearing this testimony. My name's Doug Yazwe. I'm the superintendent at Cheshire County Department of Corrections, representing the County Corrections Superintendent Affiliate. We are in support of House Bill 1270. In fact, we are the group that initiated the process of seeking changes. Over a year ago, we identified an issue of significant concern with the language. Representative Shapiro spoke to this primary concern. I'll address that in more detail momentarily, but the real concern is that the current language in the statute requires us to provide a response and services for persons held for protective custody that are largely unavailable within the current resources of our jails, as well as the local communities. Given this, we propose as a priority change within the amended bill, the elimination of language in B:3, Roman numeral 2 through 4, that most notably includes the requirements that jails immediately upon lodging the individual contact a designated alcohol counselor, clinical staff person of an approved alcohol treatment program with detoxification capabilities, or a professional medical staff person at a licensed general hospital emergency room for screening. Well, these resources don't exist. None of them, not even nursing, exists in 6 out of the 10 jails on a 24/7 basis. That language implies bringing someone out to see a counselor. Clinicians and mental health or substance abuse counselors are not staffed 24/7 in our jails, nor were they ever, that I know of, and at the time of the language in this statute. That is our primary concern. Seeking the resources outside, should we try to do it, is neither practical nor affordable, especially given that the law, as you've heard, allows us to hold the person for only up to 24 hours. And often that period of detainment, as you have heard, is significantly less. Just as the officer on the street has an opportunity to find a responsible adult to take care of that person, we have that opportunity beginning as soon as we do take custody. And sometimes we'll release a person within a matter of a few hours to a responsible adult. So the idea of bringing them out to the community to get those resources, given this is a protective custody hold especially, and the timeframes involved, makes no sense to us. Now, additionally, under section Roman numeral 1C, the proposed amended language now states, if in the judgment of the peace officer or the county correctional superintendent or their designee, the person is experiencing a potentially life-threatening medical emergency, they may require the police agency to have the person cleared by the emergency room of a licensed general hospital prior to receiving the said person. It still does include the requirement, after medical clearance, that we shall not refuse to admit the person. Now, I'm going to say we are not trying to use the emergency room to replace our lack of resources. This was really a minor change to something that's really to make something more explicit that's already happening, rarely but occasionally. Both with protective custody holds or charges, it really does not matter. We often make a collective decision with our law enforcement police partners about seeking medical care. Our recent data from 2023 among all jails, we pooled the data. About 0.5% of the time are we, quote, refusing, or by agreement in many cases, redirecting that person to get medical attention. As to the definition of life-threatening and the debate about that, that is a judgment call being made by law enforcement, because most of the time, neither the officer on the street or in the jail is going to have anyone medically trained to help make that call. Although we've added that language into this proposed bill, it is really not changing anything that's been happening. And I can't speak with certainty to every county, but for the majority of counties, I think we partner together and make that decision responsibly. And often we agree as to when a person needs to go up for medical clearance. The last change that's in here, and I again emphasize it's really a standardization of existing policies and practices. There's some minor language change, and that amended language now does state, quote, where possible, contact a family member or responsible adult and release the person to this individual who's willing to assume responsibility for the intoxicated or incapacitated person. The changes to this subsection are, again, relatively minor, simply suggesting where possible, the police make an attempt to call or otherwise contact a responsible third party before resorting to option C. That would be transporting the person to the jail. As you heard the sheriff say, that often happens anyway. It doesn't always happen. It's at the discretion of the officer. Nothing ultimately in the language of this bill removes that discretion or compels any different action or behavior on the part of the police before bringing a person to us. There was some concern among the municipal association that it would interfere with their discretion, would create more time making an assessment about a probability of harm, and that could increase expenses. Again, if you look at the language, it's not compelled in any way, shape, or form. In summary, our primary concern was to remove that language that promises or requires care and services that cannot be provided in our jails right now. I would say this, that if the committee were to see the other language as a significant obstacle, we would be willing to forego those changes as long as RSA 172B:3, 2 through 4 was repealed. Lastly, I'll just touch on a couple things that came up in discussion, if I could, anticipating maybe I could help answer a question that arose earlier. There's no intention on our part to remove a local police department that has the capacity to jail or confine somebody. There certainly was no intention to remove that option or resource. If that occurred in the editing of the bill, that was a mistake. And the question I think Representative Roy asked, could this result in an increase in charges? I'm not really sure how that would possibly happen. What I said is true about a protective custody hold or somebody that's presenting with charges. If there's a life-threatening medical emergency, we are not going to take custody of them. Every one of our booking supervisor staff at the jails are instructed in their judgment to not take somebody if in their judgment that person is potentially going to expire on our watch. It's not in the current statute for protective custodies, but it is in fact what happens on occasion. And as I said from that data, very rarely. I would admit there may be times where there's not an agreement between the police and the correctional staff about when should somebody go up. The sheriff mentioned somebody who's smashed their head off the cage while they're intoxicated. They're bleeding out. They need stitches. We don't have anyone in the facility to give them stitches. That's not life-threatening, but honestly, that's a situation where we probably are going to agree with the police and the corrections supervisor. That person needs to get stitched up, come back to us, and then we will admit them. Whether they're facing criminal charges or protective custody, that disposition and that screening process would look very much the same. I'm happy to take any questions you might have.
Thank you. So looking at the first part that your main intention of the bill with regard to Roman 3. As I said originally, my reading of that seems to be that all these things here are provided or mandated so that the person can be proved to be definitely incapacitated. In other words, they won't be held without actually proof of that. I was looking at other states. I looked at the state to our south, and Massachusetts has no mention of any of these things. There's this very quick, simple. It would resemble ours if we took that out. So let's just speak to that to ensure that someone is screened for intoxication in the first place. Do you perform, or do your facilities perform, any kind of sobriety check when an officer brings someone for protective custody? Do you have breathalyzers there to check their?
We do have breathalyzers, but to be honest, we do not always use the breathalyzers. We're really going off of the officer on the street's judgment, their description of what's happened, and our own observations of that person's behavior. And a significant change from 1989, when I think the last edit happened to this language, we are not talking about alcohol all the time or nearly as often. And we do have impairment and intoxication and incapacitation based on drugs, and a significant change in the landscape of what's being used out there. So a certain percentage of the time, it's not about alcohol anyway.
Which raises an interesting question. So when someone comes in and they appear to be perhaps under the influence of opioids, fentanyl, whatever, what have you, what is the procedure when someone presents like that for protective custody? What do you do? Do you just hold them and watch them? Do you administer Narcan? What happens?
If they're in need of Narcan and at risk of, severe withdrawal, then we have Narcan and we would administer it. But we observe them directly, and we do have a better capacity than the officer on the street for those basic observations, for use of a holding cell for someone who's uncooperative. We don't have a better capacity in many cases for medical screening, though. But we will hold them, and we can hold them up to 24 hours. But if we can find a responsible adult, the person's agreeable to leave with them, and that responsible third party will take care of them. They're not charged criminally. They'll leave the facility at that point. Again, barring any sense of a medical emergency that's going on.
Representative Selig and then Muse.
Thank you very much, and thank you for taking my question. Everything that I'm reading in this is about releasing someone to the custody of a competent adult. And I guess where I'm maybe, and this is maybe my own lack of understanding of things, but if the person sobers up, do they get released to their own custody? I mean, like, what happens when the person, maybe is no longer under the influence, or whatever issue was causing them to be incompetent has been cleared up?
That's a good question. In some percentage of cases, we can't find a sober, responsible adult, can't reach them, or they're not willing to come. That's a situation where we're more likely to take some more time to ensure that they're no longer intoxicated or incapacitated at a level that's unsafe. And in that case, we will transport them out of the facility to a safe location or to home. So it is not necessary to always have a third party come and pick them up.
Representative Muse.
I wanted to focus a little bit on the kind of back on the bill itself. So one of the things that we heard is there are concerns that the bill might be perceived as a mandate for police officers to use their judgment to transport people to a medical facility in the event of a life-threatening situation. It would seem that in the event of a real life-threatening situation, most police officers would transport somebody directly or call for an ambulance. I mean, as I read the statute, and tell me if I'm wrong, what it looks like the bill does is it actually gives police officers discretion to either take people directly to an ER or to take people to the county jail. But it also looks like you have the discretion to make the same decision. So for instance, if in your judgment you believe that the person is in a life-threatening situation, you can transport them. Now, I guess my question is, in the event that happens and the police officer is left, I'm assuming that the county would then be responsible for the transport, or would just simply call an ambulance for the person?
If it was life-threatening in the way that we're describing in the language of the bill, we would be calling an ambulance. But nothing changes the discretion of the officer on the street to bring the person to a hospital or call an ambulance. And I'm sure in many cases that is what happens. Sometimes at the point between putting the person in a cruiser and getting to the jail, their condition can change, especially with drugs and drug overdoses. There have been some instances where I think appropriately in the officer's discretion on the street. Person was not at risk, but arrives at the facility and their health, their status has changed. Perhaps an example, an overdose. Again, it's 0.5% of our total bookings that we divert somebody to a hospital. It's not very common, and nothing in our intention of the language is to take away anybody's judgment, neither the police officer's judgment about how to dispose of the best disposition of that detainee or at our receiving end. And I again will tell you that all of our booking commanders are instructed to never accept somebody into our custody if you believe they are in a truly life-threatening situation. I would rather take the liability of refusing somebody in an argument. And again, I don't think in those cases we are in an argument with the police in a life-threatening situation. But that's what happens now. It's just not been in statute, and we wanted it in there, but.
Thank you.
Hold on. For clarification though, so if someone arrives, let's say they, it was for what you said for fentanyl, and while in transport, they go into OD and they're out. It's not like the corrections and law enforcement are playing hot potato with somebody's calling an ambulance at that point, because the cruiser's not equipped to transport medically people either. So at that point, everything stops and ambulance is called. Is that correct?
That would be correct.
Okay, thank you. Representative Stone.
Thank you, and thank you for taking my question. Under the current system, and quite conceivably, as a practical matter, isn't the Department of Corrections on the county level the best place to get an individual, since we've heard there have been instances of being highly combative? There could be a mix of alcohol and or drugs on board, or I'm sure you dealt with some people that have outright refused to cooperate overall. Isn't that the safest for the public as well as the officers involved to get the individual to a place that's secure with care, custody, and control?
Absolutely. And nothing in this bill would change that from happening.
Thank you.
Representative Newman.
Thank you, Mr. Chair. Thank you for taking my question, and I apologize if you may have commented on this, but I'm curious as to, in the current law, the removal of Section 4. And that's the part that says jail or county shall not refuse to admit an intoxicated person, etc.
It still remains in there after medical clearance. So it includes that condition now that having a life-threatening medical emergency cleared at the hospital, and then the language that still exists immediately after that section states that I don't have it in front of me, but the jail will
It says they can't refuse after they've been
will
medically.
then admit, the local jail or county correctional facility shall then admit the person.
Thank you. I just had a hard time finding that. Thank you very much.
Representative Prue.
Perhaps I can add a little clarification. As being a town that lives, that is next to the Rockingham County facility, I have, on a number of occasions, met up with a cruiser to take a patient who went south on them while transporting to the jail, and also have ended up at the booking office of the jail to get patients who were determined shouldn't be in there at the moment and needed to go to the hospital. So that practice does happen. Somebody calls an ambulance for these people, and we take them to get their screening and get medically cleared.
Mm-hmm.
Any further questions? Seeing none, thank you for your testimony.
Thank you.
The chair calls Dustin Parent.
My name is Dustin Parent. Been a full-time police officer for 21 years. Hold the rank of captain at Guilford PD. Been there my entire career. I'm here today to speak on behalf of Chief Kelly and the New Hampshire Chiefs of Police. I was going to speak on basically everything that Sheriff Wright discussed. I don't think that my redundancy is going to do the committee any justice, and I'll save you that, I suppose. So I am in opposition to House Bill 1270-FN. I will just speak what I can more personally and intelligently on, which would be the section speaking about potentially life-threatening medical emergencies, which seems to be where we just left off anyway. And I agree with Representative Prue that does happen. The ambulance does need to be called at times. I think that confusing a police cruiser and a police officer with trained medical personnel is definitely a mistake. So we have the venue of Bank of New Hampshire Pavilion in Guilford. We're lucky, we'll say. We have approximately 400 protective custody cases a year that come out of there. So I don't know what other agencies' statistics are, but I will confidently venture a guess that we, if not at the top of the state, are very close to that. So we have a lot of experience with this, and we are having some issues with regard to getting turned away at the jail. So we like to hold our training accountable, that we're able to determine if a person in fact does have a life-threatening medical emergency, that we would not be bringing them up to the jail to begin with. And should they bring them up to the jail, then we would have a different problem on our hands, which would be training and morals and ethics of that particular officer at hand. So that is certainly not something that we foresee being an issue, but allowing that to be, again, redundant, to say the police officer is going to determine whether or not this individual has a life-threatening medical emergency, and then another person, i.e. the jailer at the correctional facility, then confirming or not confirming, whatever that person's opinion might be, is where we're going to run into our issues. So we have staffing issues like anyone else does. We have to have approximately anywhere from 16 to 20 officers per show. And I speak solely on Meadowbrook or Bank of New Hampshire Pavilion, but understand we have Bike Week and we have the Gunstock ski area. We have the hill climbs that are in our town. So there's a lot of different events. It's just that the Bank of New Hampshire Pavilion carries the most amount of work and quantity of these types of cases. So I'll refer to that throughout. So our issue being, if we're going to continue to rely on the redundancy of the jailers to turn us away, it incurs a significant cost to us as well. And we're not able to get our people back at the venue. And to keep in mind, these people have already been evaluated. Should they show any signs of needing medical attention whatsoever, there's paramedics 24 hours in our town. In most towns that surround us, I can't speak to the rest of the state, but certainly at the venue, there's paramedics on scene. They're detailed to that particular venue, so they've already been cleared. And if they speak anything about having done drugs or ingested drugs at any point in time during the day, we're getting told to get medical clearance, even though there's no sign of life-threatening medical emergency. I did hear you, Representative Roy, ask what type of protocol do you go through with regard to determining if somebody is impaired? So everything that we do at the Guilford Police Department is on body-worn cameras. There's also closed-circuit monitoring throughout the whole venue. So we have policies in place that we do standardized field sobriety testing. We offer preliminary breath tests to these people, and that's after observations such as physical observations are had of the person to determine if they're impaired. Odor, things like that comprise and then lead us to the direction of this person's impaired due to alcohol, drugs, whatever it might be. And that decision is then made. We do our due diligence, as does, I speak confidently that all law enforcement does their due diligence to find a sober party for this person, because we don't want to drive them to the jail. We don't want to end up there and take that person off the road. I know I alluded to the Bank of New Hampshire Pavilion. We have several officers, which still isn't enough. I hope you can trust me in that. But the people on the road working a midnight shift might have one or two officers on duty, and then taking them off the road can also pose a problem for community safety, having them sitting in a hospital. So as I said, my main concern, yes, I think all of it carries the same amount of weight that Sheriff Wright spoke on. I just wanted to speak more pointedly to this particular section, as I think I have some experience in that area.
Thank you. With regard, so let's stick with your example. You've got an event going on at the Pavilion, a concert, that you have a lot of intoxicated people. So the officers you have there are on detail, right? So they don't have cruisers. They can't transport. It's up to is it up to the on-duty officers to handle the transports, or how does that work as far as tying people up?
Yeah, that's a good question. So they are on detail, and just to kind of just a quick synopsis. So regular patrol, as opposed to being on detail, means that the venue themselves, Bank of New Hampshire Pavilion, hires the police officers, the police department, to be there. So they're not responsible for handling calls throughout the community during that time. So part of that detail is that there's a transport van or 2 or 3 at the venue. And then the officers that are there for the detail would be designated by the supervisor to then take them to the jail should it be time, if you will. So we have probably 3 or 4 people could be held on. It's not made to hold people, obviously, for long periods of time, but we have about a facility that'll hold 3 or 4 people per cell, and there's 2 cells that are there, pending that they're not combative or male, female, juvenile. Obviously, there's laws that prohibit us from doing that. So the short to your answer is those people get transported by the detail that are at that venue.
So as a follow-up, if they get turned away, or any number of them get turned away, who gets to go take them to the hospital then? Is it the detail officer still? Are they getting paid detail rates? Does the Bank of New Hampshire agree with paying, the New Hampshire Pavilion pay for all those hours?
Yeah, so in the example of being turned away during a concert by one of the detail officers that was doing the transporting, it would be them. We wouldn't be tying up our patrol units. We're just too busy for that. So the detail officer would then have to go to the hospital, at which point in time we lose our transport van, and then we lose that officer that we really can't afford to lose to begin with. So we're not asking the jail to do something or take on a responsibility that isn't unreasonable. We're simply saying to trust us in our ability to evaluate the person, and the paramedics that are on scene to evaluate the person, to determine if it is in fact a life-threatening issue or emergency, that we would have brought them to the hospital to begin with, or allowed the on-duty ambulance to transport them, and not tie up our officers that already determined that they were fine to go to jail.
Are you familiar with 172B:3, the protective custody statute?
I don't have that in front of me, but
Okay.
try me.
Well, I was going to ask with regard to Roman 3, that says no person shall be lodged in a jail or county correction facility under paragraph 2 unless the person charged immediately upon lodging said person protective custody contacts a designated alcohol counselor, clinical staff person, approved alcohol treatment program, detox case. It goes on, and it culminates in the point of that that all those people are to determine whether or not said person is indeed incapacitated. Right. And then it says, if and only if none of the foregoing are available, such medical clinician determined shall be made by a registered nurse. Apparently they don't have those either. So would you agree with my interpretation that this was put in there as some type of protection for a citizen to prove that they are indeed intoxicated?
I can't speak to what the intent was, but
or what
I will agree with you that it makes a lot of hoops.
And what is your opinion if we would just strike that paragraph?
I think that the manner in which we've been doing business, by taking care of the public, making sure that we're not doing anything out of malice, which I have never witnessed, fortunately, that I think that we were doing things properly to begin with.
Well, you're already given field sobriety tests, and you are from a preliminary breath test.
That's right.
That's correct. And no one's barred from bringing a cause of action against the police department for false arrest if they can prove they weren't intoxicated. If they have friends or witnesses, I mean, they're free to bring that. Is that true?
That is true, and I have been on the other end of those complaints multiple times. And I alluded to earlier when I was testifying that our body worn cameras, our booking facility is all videotaped. So those types of things are what we fall back on to ensure that our policies are followed with regard to offering standardized field sobriety tests and preliminary breath tests.
Thank you. Representative Newman.
It's just a question of the chair. That section that you read, section 3 in 72B3, isn't that repealed by the language on page 1, line 23?
It is, but
So
the bill
that's-
also adds a bunch of other things that aren't germane. And the
I've-
superintendent said that this is the thing that were most important. So I was curious as to the effect of law enforcement.
But I just wanted to make sure that that this takes that out. Okay, thank you.
Representative Mannion.
Thank you, Mr. Chair. And this is not really a question for the officer, but you made a statement earlier about the detail and who would be responsible. Every agency is different. I know the agencies that I've worked for, the detail officer stays at the detail. A patrol officer would come and handle the call and transport the person. I guess the thing is that people are paying for a detail. If all three of them are gone now, nobody's covering that facility for the night. So we have some times where there's one officer on the detail and he can't leave.
Well, I'm aware that detail pay is higher than a normal salary. And if an officer's on the detail for you and then they're tied up at a hospital for 14 hours in an emergency room, who pays for that? The person might say, I'm not paying that. That's not what I hired you to do. Representative Salick.
Thank you, and thank you for taking my question. I'm curious if there's just in your experiences in Guilford with the concerts and the various events in that area, whether there's impact of people who are under the influence of hallucinogenics that need to go into protective custody for their own safety to some degree as well, or if there's an impact from that.
So you're asking, do we come across people that are impaired from narcotics, not just alcohol?
I'm sure you come across people who are impaired from narcotics, but we last year heard a lot of testimony about people wanting us to decriminalize various forms of hallucinogenics and having, I don't remember the term they use, but basically sessions where they bring people in to give lots of, I don't remember the name of anyway, drugs that are similar to LSD, except maybe created differently. And so I wasn't sure whether you have been seeing impact of people under the influence of things like that.
Absolutely.
In a noticeable way.
Yes.
Have you picked up a lot of people on shrooms?
We yes. And to be honest with you, a lot of people probably what you would think is to the opposite is they admit it to us. A lot of these people tell us because they're scared when this starts to happen to them, to their body, and they tell us, and they're given medical treatment at that time. Like I said, we have paramedics on scene, or if they need to be transported to the hospital.
Is your agency accredited?
We are not accredited.
Okay. In your understanding, many of the departments are accredited across the state. Do the accreditation standards or even your department policies speak to what you do if you encounter someone, regardless of it's a PC or an arrest, and they have a visible injury?
It does.
What's the first thing that's to be done with them?
Ironically, I am the one that is handling our accreditation process through the state. The state is, as you probably know, is going to be offering that. So yes, we do have a policy that speaks to that, and they immediately are offered and afforded medical attention.
And that's prior to bringing them to their destination, be it to a friend's house or to jail.
Yes, they're afforded medical attention prior to going to the jail should they need it.
Thank you. Representative Mannion.
Thank you, Mr. Chair, and thank you for taking my question. Actually, it's more for clarification. This law currently, as it stands in the bill, only apply to alcohol intoxication, correct? Not drugs.
Correct.
Just so everyone's
yes.
on the same page with it.
Correct.
Okay, thank you.
I did have one more point that I had heard throughout the testimony here today, and it was with regard to the condition worsening, prior contact with the officer. Having evaluated that person, the officer evaluates, decides this person is ultimately going to be getting PC'd, and then the condition worsens in the cruiser, and that's the ability to turn them away. I I speak on behalf of the Guilford Police Department that we do the exact protocol that Representative Prue alluded to. We would not then be turned away and transport them. We would be saying, well, we need to call an ambulance at this time. So should that situation worsen and then becomes potential overdose or life-threatening injury or something like that, we wouldn't then be transporting. We would be going with an ambulance. So the language doesn't really support what our actions would be.
If in the middle of transport, you look in the rearview mirror and your transport's keeled over, do you divert to an emergency room or do you pull over and administer first aid and call an ambulance?
That B.
Thank you. Representative Newell.
Thank you. And thank you for taking my question.
Yes.
You mentioned that there has been concern or there have been instances where people are being turned away from correctional facilities, right? And so, another thing that you mentioned was, to trust your judgment, right? What this seems to do in my mind is it says either the superintendent or the peace officer, it would be either one of their judgment, right? And so what I'm wondering is when they're being turned away, as you've seen recently, is it a difference between their judgment? You know what I mean? Is the feeling that they're unnecessarily being turned away?
Yeah, that's a good question. And I believe, I know predominantly there are going to be various other instances where the turning away could have taken place. However, a lot of it is erring on the side of caution when the person says that they've ingested some type of narcotic at some point during the day, then that person, the jailers are erring on the side of caution. Okay, get them medically cleared, even though there aren't any signs of needing a life or having a life-threatening medical emergency.
Can I follow up really quickly? Thank you. And I'm curious about the idea of someone coming in who is intoxicated in one way or another, whether it's alcohol or drugs or something like that, and the ability of having someone in the facility versus in an emergency room, of the ability of that person to be able to receive, medication assisted treatment or, something like that, that would help them that would improve their chances of recovery or something like that.
Right.
Do you think that there's, better odds of that being available at an emergency room or in a correctional facility?
I can only speak to the county in which I work. So when asked with a conversation with staff superintendent in the county in which I work, the staffing was a problem. So having the nurse on duty 24 hours a day wasn't feasible for them. So that's why they were unable to do their own evals. Whereas if it happened during business hours, we'll say, and that nurse was there, then it was portrayed to us that evaluation would then take place at that time. And if not, then the police will be deemed with that responsibility to take them to the hospital and be turned away ultimately.
Thank you.
No further questions. Representative Stone.
Thank you. And real quickly, thank you for taking my question. In the case of you lodge somebody as a PC at, say, Belknap County, and within an hour, an ambulance is dispatched, who ends up providing the security coverage for that individual when they are sent to the hospital?
I'm going to say I don't know. With that said, I'm confident that it's going to be the Laconia Police Department because that's the jurisdiction in which the jail is located. But I say that only based on, I guess, using my common sense to it because the jail isn't trained to do that. To answer that more directly on behalf of the Guilford Police, we have never been called to go back and provide that security for the ambulance, only leaving Laconia PD to be the ones to do so.
Thank you.
Thank you for your testimony.
Thank you.
Is there anyone else wishing to testify on this bill? Seeing none, I hereby close the public hearing. We'll be back Friday morning.